Good morning, everyone. By my clock, it's 10 o'clock, so the hearing is now open. My name is Emily Catchside. I'm the inspector appointed by the Secretary of State to conduct this hearing. Before we start, inevitably there's some formalities to go through, so it can take a little bit of time, but please bear with me while I do that. If you haven't already, please can I ask that you switch off any mobile phones or electronic devices, or otherwise turn them to silent. And I believe we're not expecting a fire drill today, so if we do hear the alarm, it will be real. Can I just ask the council to explain what we'll need to do if we need to evacuate?
Yeah, so there's a door just at the back there. So we just go through, down the stairs, and then we meet outside the Wetherspoons pub is where we have to stand.
Thank you. So I believe that we're being live streamed today. That does mean that when you're speaking, I understand you need to be near a microphone. And it looks to me like everyone has access to one. Is there anyone that doesn't have access to a microphone? And does everyone understand how to use the microphone? Okay, I inevitably will forget to press the button, so please draw my attention. I believe that we have to press the button to speak and then press it again to not speak. Is there anyone else that intends to film or record the proceedings today? So firstly, I just want to confirm who's here. I have had a list in advance from both the appellant and the council, but just so I know who's who, can we do introductions? So if we can start with the appellant side, please.
Good morning, madam. My name is Heather Sargent of Council. For the appellant, you hopefully won't be hearing very much from me because obviously I'm not giving evidence on the substantive issues, but I'll just explain who's who really and what they're going to speak to you about. So to my immediate right is Mr. Robert Hughes, who is dealing with landscape matters, and then to his right is Jamie Pratt, who is dealing with tree issues, and then immediately behind me is Mr. Nathan Hanks, who is covering transport issues and may also speak around a sort of engineering feasibility in respect of the root protection area on Tree T2, which is an issue. And then to his right is Ms. Philippa Robinson, and next to her, Mr. Andrew Watson, both from Savills. Mr. Watson is likely to lead in terms of speaking to you. And then finally, to the right of Mr. Watson is Mr. Tim Burrow from the appellant.
Thank you. I had a Miss Keat as well on the list.
Sorry, Miss Kite's not actually attending, madam. Thank you.
Thank you. And for the council?
Thank you, madam. My name's Andrew Bush. I am the Arboricultural Officer in Planning at Horsham District Council.
Hi, I'm Kate Turner. I'm the Senior Planning Officer leading on the appeal for the council.
Dan Holmes, Senior Planning Officer from the council.
And how do you pronounce your, how do you spell your surname?
Holmes.
And is that Dan, D-A-N? And sorry, did you say you're a Senior Planning Officer? And I believe we have some other participants today. If you're intending to speak, I will need to take your name for my decision letter. So can I ask who might be planning to participate today?
Thank you. My name is William Aikenhead. I'll spell that for you. Aitkenhead. And I'm here representing Storrington and Sullington Parish Council.
So just that's William, Aitkenhead.
Correct.
Good morning. My name's Claudia Fisher. I'm a District Ward Councillor for Storrington and Sullington Ward, and speaking as a ward representative. So that's Claudia, Claudia, Fisher with no C, Fisher. And I'm also speaking as chair of the Storrington Traffic Group.
So sorry, you're speaking on behalf as a ward councillor.
A ward councillor, yeah, and also I'm chair of the Storrington Traffic Group.
And are you speaking on behalf of the Storrington Traffic Group today as well?
Yes.
Good morning. I'm Mark Appleton. I'm a resident of Downlands, just off Newtown Road, and I'm a member of the Backs Close group of residents and will be speaking on their behalf.
Good morning, my name is Murray Chisholm, Chisholm. I'm a resident and I'll be speaking on behalf of the Backs Close group.
Thank you. I was advised there was going to be a statement read as well on behalf of the Backs Close group. Is that still the case, or have we got?
Yeah, I've got that statement and I'll be reading that.
Okay, thank you. But the other, that was on behalf of some different names, but it's just on behalf of the Backs Close group. Thank you. And are there any other statements to be read today, pre-prepared statements?
I got permission to also speak, but I haven't submitted anything in writing. I have it here.
That's fine, but you've got a statement you'd like to read.
I will. Thank you.
Okay, thank you. Because I know there are a couple of statements, I'll probably do that quite early in the agenda, just so that you've said your statement, but you're welcome to stay and participate in the discussion for as long as you'd like to throughout the day. And just to be clear, if there's anyone here that hasn't registered their name, but you do decide that you'd like to say something, that's absolutely fine. I will need to take your name if you do decide to speak, but just get my attention and I'll bring you in at the appropriate point. So the purpose of the hearing today is to enable all of you to put forward your points of view and so that I can gather the information I need to make my decision. It will be based on a structured discussion which I shall lead and based on an agenda which was circulated earlier this week. Does everyone have a copy of the agenda that needs one? You don't have a copy of the agenda. Do we have any there? I do have some spare copies if need be. Do you need one of my spares? Is it just one you need over there? Thank you. So during the discussion today, I will first invite the two main parties to answer questions or to comment on specific issues, and then I will open up to comments from others. I will ensure that everyone has the opportunity to speak. However, if you feel I'm moving on too quickly or you want to make a particular point, please just raise your hand to get my attention. Please do, however, ensure that only one person is speaking at a time without interruptions. And whilst this will be a formal discussion, it's not a public inquiry. Therefore, please direct all questions through me rather than directly to each other. And there may be instances today where I nod, smile, I might say thank you. Alternatively, I might look a little bit serious at times. Please don't read anything into any of these mannerisms. It's either an acknowledgement that I've heard what you've said, or simply I'm just thinking about something that's already happened or that I need to do later on today. And I will be taking notes throughout the hearing, so there may be some pauses to allow me to do so. It also means I might be looking down at my notes, but that doesn't mean I'm not listening. Please just bear with me with that. And we do have quite a lot to get through today. I intend to take a break late morning and then a longer break, probably quite a sort of late lunch. But we'll review the timings and the durations of those depending on how we're moving through the agenda. Are there any sort of time constraints that I need to be aware of at all today? Excellent. So I've received a copy of the Council's letter of notification of the appeal and also of the hearing and the lists of people notified. From what I've seen, the hearing has been appropriately publicised, and unless anyone has anything to say to the contrary, I'm satisfied that the hearing can proceed on this basis. I've received a number of representations in response to those letters, which I've read, and I've also read all of the consultation responses and representations provided at the planning application stage. Please therefore be assured that I will be taking account of all of the comments made when I'm making my decision, even if I don't have specific questions on an issue that's been raised today. That simply will mean that I have what I need from the written evidence. So when I arrived in the area yesterday, I took the opportunity briefly to familiarise myself with the area around the appeal site and some of the places mentioned in the evidence. I walked along part of Amberley Road, Newtown Road and into Backs Close, and also along the footpath as it crosses the site and to the north. Do I mean the north? As it comes out the other side into the field. I've also received a suggested route map for the site visit that I'll be carrying out later today, which I believe was agreed between the appellant and the council side. We will look at that later today, and I'd welcome any other suggestions of places that I should visit. So later on there will be a site visit either today or tomorrow morning. I'm hoping it will be today, but as I say, we do have quite a lot to get through. Having seen the site, it does occur to me that I could potentially carry out the site on a site visit on an unaccompanied basis if I've got permission to enter the site. But I'm conscious that there were some people that wanted to accompany me. So I have no objection to being accompanied. It's likely, however, that I will close the hearing before the site visit, so there won't be any discussion on site about the merits of the appeal. It will purely be for me to see the site and the surroundings. So I would just, maybe reflect throughout the discussion today whether it's necessary for the site visit to be accompanied or not. If it is accompanied, I will of course need a representative from both the council and the appellant to attend. Would there be any sort of issues in whether it was later today or tomorrow morning? Fabulous, thank you. As will be seen from the agenda, we will be discussing conditions and planning obligations today. For those unfamiliar with the planning appeal process, this is standard practice, and it will be a discussion about the conditions and obligations that may be appropriate in the event that I decide to allow the appeal. The fact that we will have this discussion does not mean that I've made my mind up on the appeal, and the council's position is also not prejudiced by them taking part in this discussion. It just purely gives everyone here the opportunity to comment on the conditions and obligations that could be imposed. At this stage, I propose to base the discussion on the list of conditions in the Statement of Common Ground. So therefore, it would be helpful if you could have that to hand when we get to that session. And in terms of the Section 106 agreement, I received a copy from Ms Turner at 16:09 yesterday. I think it was emailed. Is that the latest and up-to-date version of the Section 106 agreement? Okay.
Madam, just on the section 106, so the substantive terms of the obligation are agreed. There's one point outstanding, which is around the signatories, and as I understand matters, particularly because a trust is involved. We've prepared, and I think this is now agreed with the council, just a page basically that explains for you what that point is that's arisen. Essentially, the council, I think, took legal advice on the point, and so that specific aspect of the drafting around, what wording do we need to make sure the signatories are appropriately tied into the obligation is the final point that hasn't quite yet been agreed between the council and the appellant. So if you're happy, I can hand up this note so that you can understand in more detail, what I've just said. But the short point is, we'd ask if you're comfortable with it for to have time until the 30th of June just to give you the final fully executed, fully signed document. So that's in short a summary of where the parties are on the Section 106.
I think we can look at the timing later when we look at the actual planning obligation issue on the agenda. I think it would be helpful for me to understand the issue between you. So if nobody has any objection, I'll accept the document. And this is agreed, is it, between both main parties? Thank you. And then I'll familiarise myself with that at the break. But I mean, just for my information, is this an issue that's likely to be resolvable by the 30th of June? Yes.
And our legal representative said that it's very likely to be resolved. It just needs a bit of time.
Okay, I think we'll revisit that later today.
Madam, just the copy I've just handed you obviously says draft. We can provide a copy that doesn't say draft and has the signatures on it later today. I think we're just getting that printed, but it won't, the words will be the same.
That's fine, thank you. And if you could email a copy to the case officer as well. Thank you. And if there are any interested parties that would like a copy of the conditions or the draft Section 106 agreement for that session, which will be this afternoon, can I suggest that you bring that to the council's attention at the break, and then hopefully that can be arranged for copies to be provided. So I'll not be inviting any applications for costs today, and I'm not aware of any having been made. If any applications for costs are to be made, this should be done before the close of the hearing, ideally in writing, and there's an item on the agenda to allow this to take place. And just to make you aware, I do also have the power to initiate an award of costs, even if no applications are made. If I were to do this, it would follow a written process with the relevant party after the appeal decision has been issued. So as far as I'm concerned, I have all of the written evidence required for me to determine the appeal, and I'm not expecting or inviting any late evidence. It can cause delays to the hearing process should late evidence be submitted, and I'll not be accepting any additional documents unless there are exceptional circumstances. Having said that, if anyone does intend to submit any further evidence, please, can you tell me now? I've based the agenda on the written evidence that I've already seen. It is my understanding that the council is no longer seeking to defend its second reason for refusal on the decision notice. And for that reason, I've not identified water neutrality as a main issue in the appeal. Nonetheless, should I decide to allow the appeal, I would have a statutory duty in respect of European habitat sites, and therefore there is an item on the agenda for related issues to be discussed. So at this stage, I consider there to be one main issue, and this may change based on the discussion today, but the main issue I've identified at the moment is the effect of the proposed development on 1, trees, including protected trees, and 2, the character and appearance of the area, including in respect of the setting of the South Downs National Park. There will also be the opportunity to discuss other considerations and matters, including those raised by third parties, and some of which I have specific questions or points of clarification on. Does anyone have any comments on the agenda or the main issue? And does anyone have any questions on the procedure today before we get into the detail? Excellent, thank you. Okay, so that brings us to preliminary matters, and then I think I'll hear any pre-prepared statements after that. So just some points of clarification, really. The name of the appellant on the application form is Samuel MacDonald with A2 Dominion Developments Limited. Is that correct? And the site address on the application form is land south of Backs Close, Storrington, Horsham. That's correct. And there's a very slight difference between the description on the application form and the description on the decision notice. I think the application form says development of 30 number residential units with associated landscaping, public open space, earthworks, drainage, access, and all other associated infrastructure, whereas the decision notice says erection of. Was that a change with agreement? Which should I use?
I believe that was agreed through the validation of the application to change it.
Thank you. And then in terms of the plans for approval, I did receive a revised version of Appendix A, which corrected some typographical errors. Has the council seen that? It was a couple of weeks ago now, I think.
I think we did have that, I believe.
Okay, thank you. I just wanted to double check because obviously the list that I've got in Appendix A includes a number of documents as well as plans. How would I identify the plans that define the development that would normally be incorporated into a condition that does that?
That would be in Appendix A of the Statement of Common Ground.
Yeah, I'm just wondering how I would, because obviously there's a number of documents in that Appendix A. I can see that the drawings are kind of listed at the front, but in terms of the drawings that actually define the development proposed, those would normally be incorporated into a condition if the appeal were allowed. I'm just wondering how I would go about picking out what should be included in that from that list.
Madam, I think, I'll be corrected if I've misunderstood this, but I think the intention is to condition the entirety of the appendix, just so that to the extent that there's anything kind of operative in the documents, that's also secured. But we can certainly, in the break or by lunchtime, speak to the council and come up with an agreed list of which of that list at Appendix A relates to the plans as opposed to the other documents, and check that there aren't any documents in that list that don't need to be included because, for example, the substance of the point is captured by another condition. So we can look back at Appendix A and work out, if that can be narrowed down, if that would help.
I mean, I'm more than happy for you to discuss that at the break. Obviously, we'll be revisiting conditions later today, so we can pick that up then. And the Statement of Common Ground provides an update on the progress and status of the emerging local plan. Are there any changes or updates to that, or the weights that the policies of the emerging plan should carry?
I don't think the weight has changed, but I do have just a short statement that just explains the current status of the local plan, which I can read if you like. It's probably the same, but I can read it anyway. So the emerging Horsham District Local Plan is currently at examination, and initial hearings were held in April this year relating to the housing requirements and housing supply on the basis of the site allocations proposed at submission. We expect to consult on a set of main modifications to the plan in the summer, including an updated site assessment, which will include information on additional sites to meet the new housing requirement, and further hearings are likely to be held in the autumn when these modifications will be discussed. We published an updated LDS on our website setting this timetable out, and a provisional examination timetable has been published this week. We expect to publish Cabinet papers relating to the main modifications on the 26th of June 26.
Thank you. And did I hear you say that you don't think the weight that the emerging plan should carry has changed?
Agreed, yeah.
Is there anything that anyone on this side would like to say about the emerging plan?
No, if the council hasn't changed its position, Madam, we don't need to address you on that.
Thank you. Those are all my preliminary matters. So I'd like to hear any pre-prepared statements now, please. I don't have a particularly strong feeling about who goes first. Would anyone like to volunteer?
Good morning. Thank you for allowing me to speak on behalf of the Parish Council. The position of the Council and its strong objection to this proposed application is well documented. But if I may, I'd like to highlight a few areas of significant concern. The first one is traffic. This is a massive concern for the Parish Council, throughout the whole village, to be quite frank. As far as Backs Close is concerned, the increase in traffic for residents in Backs Close and the lack of pavements, cycle paths, and most importantly, the junction to the B2139 Amberley Road, which by its nature is highly dangerous. Data from the Storrington Traffic Group in the last quarter of 2025 shows just short of 1 million car movements at the junction of Newtown Road, with, depending on the direction of travel, up to 40 and even 60% of cars exceeding the speed limit. The narrowness of Newtown Road and the steep incline leading up to the B2139 is, quite frankly, highly dangerous. We believe that this has not been adequately recognised by the applicant. The council would support the view that there may be a more suitable alternative by accessing the Amberley Road from within the development, which has not, we believe, been fully explored, and as such we have no, obviously, idea as to what that could be. At the very least, should that happen, it would help mitigate traffic in both Backs Close and at the junction. The second serious concern is the likely and unacceptable loss of the tree preservation protected oak for the entrance to take place, and the general loss of green space, which acts as a buffer to the South Downs National Park just to the west. Again, a major concern. I would add that this site was not in the existing, or is in the existing neighbourhood plan, and nor would it be. Madam, in conclusion, the Parish Council is acutely aware of the pressure to find more building land in the Horsham district, but should this application in its current form be approved, it will be to the significant detriment of residents in Backs Close, also Newtown Road, and we believe pose an increased danger to all road users. Thank you.
Thank you. We do have agenda items, I think, which will pick up some of the points that you've made, and I do have some of my own questions on those issues. So I'm not intending to kind of ask the questions or seek responses now, but obviously you're more than welcome to engage in that discussion when the agenda items arrive. Okay.
As I introduced myself earlier, I'm Mark Appleton. I'm resident of Downlands and a member of the Backs Close group. This is a statement that was prepared by two other members of the Backs Close group on their behalf, and I'm reading it for them. Good morning. Our names are Rob Overton and Andrew Smith. We are both residents of Backs Close. We would have very much liked to present our views in person, but unfortunately illness and bereavement respectively have prevented us from attending, and so we are grateful to our representative for presenting this statement on our behalf. Like many others, including the Backs Close group of which we are a part, we are completely opposed to any development of the site for a variety of reasons, but for the sake of brevity we would like to primarily focus on access to the site and transport and traffic issues. Access through Backs Close risks the demise of the only remaining healthy oak tree protected by the tree protection order. Both of the other beautiful trees have been ruined by building works carried out close to them, despite measures proposed by experts which were meant to protect them during construction. Despite these measures, one tree died some years later and had to be cut down, and the other is now in obvious decline. This gradual decline and death is entirely consistent with root damage from construction many years previously, as confirmed by the Horsham District Council arborist Andy Bush. Access via Backs Close is, of course, a much simpler and cheaper option for the developer rather than creating access via Amberley Road. Whilst understanding the need for homes, we deplore the developer's attitude whereby changing the relatively peaceful character of the road as it currently exists, severely disrupting the lives of the residents while construction is taking place, and regard for the safety of vehicles and pedestrians must all take second place to their profit. The addition of 30 new homes will increase traffic through Backs Close by almost 400%, all being fed through Newtown Road, which, as we know, is narrow in places, notably at the southern end where it meets Amberley Road and where, in addition, there is no footpath present. Factually incorrect information was previously presented to the committee at the original hearing, with no opportunity to correct it due to the procedural rules. In particular, the pavement along Amberley Road is not 6 feet wide as stated. Photographic and dimensional evidence has already been provided. Also, the nearest supermarket and post office are at least 20 minutes walk from the site. It is completely unrealistic to think that cars will not be used for journeys into the village. Public transport is hopelessly inadequate, perhaps running once an hour for a limited periods of the day and ceasing after around 5 p.m. There is no local train station, so even accessing rail travel will require the use of private transport. The developers have not put forward any alternative plans that involve access via Amberley Road because it is much more difficult and more expensive, even though it is so blatantly obvious that such a scheme would be less disruptive and indeed have potential benefits to the community regarding traffic safety. As such, there are no alternative plans to consider today, only the one being discussed. This is down to the developer. When the planning inspector found in favour of the planning committee decision to deny planning permission on the site back in 2016, he at least had 2 options to consider, and the single appeal encompassed both. Both were, of course, refused. There are many perfectly justifiable reasons to deny permission for the current plan, not least of which is the potential to kill the TPO protected tree, and it is the developer's fault that they have failed to offer an alternative access solution to consider. We would respectfully ask the inspector to turn down this appeal. If the developer subsequently wants to start the process all over again and submit further plans incorporating sole access via Amberley Road, then of course that is their prerogative, especially if their main motivation is to serve the public by providing more homes. They will experience very strong and determined opposition again, but that is their decision to make. In addition, we note that the very recent appearance on the site of signs saying it is private land, which has caused something of an outcry on Facebook. This field has been in use by the public for over 25 years, and there are well-worn paths evident on the site. We have people who can testify to their use for this period of time, and we believe there is the potential to protect those areas of the site and would like time to explore this. Please deny this appeal. Thank you.
Thank you. And I have seen some photographs that have been submitted of the footway, which I believe is between Newtown Road and the sort of centre. I will also, I intend to walk that route.
Good morning, and thank you for giving me the opportunity to speak. I do have a slight speech impediment, so if you don't hear me, raise your hand or whatever. To make it absolutely clear, I fully support the submission of the Backs Close residents to turn down this application. My name is Murray Chisholm. I've lived in Warrencroft for 40 years. My house is less than 300 metres from the proposed development. I know the field where the development is proposed intimately, from walking my various dogs there for the last 40 years. I walk 4 times a day around Storrington, and I probably know more about the locale than almost anyone else. I'd like to address 2 areas. Firstly, pedestrian safety, and secondly, road safety. Pedestrian safety. The application indicates there is a footpath access of 2 metres wide all the way into Storrington. This is absolutely not the case and totally misrepresents the position. So much so, I wonder what other misrepresentations have been made. The quickest way into the village and the primary school, because I make the assumption that there will be children in the new development, is via Newtown Road and the Amberley Road. This would be the logical way for Bats Close pedestrians to walk. There is no pavement between Newtown Road and the Amberley Road from Bats Close. At the junction of Newtown Road and Amberley Road, there is a steep grass verge on which I have slipped on many occasions, trying to keep off the road. The thought of young mums with pushchairs and youngsters in tow frankly terrifies me, and trying to avoid traffic on a blind junction. Typically 40%, and it may be higher, of cars from either direction travel over the 30-mile-an-hour speed limit as we move from a 60-mile-an-hour speed limit coming into the village. Those who are coming out of the village are frustrated by the total congestion that we have within Storrington, and then on the road out of Storrington, which is a straight of about 500 yards, put the foot to the pedal. And myself, I have been nearly hit on a number of occasions. The Storrington Speed Community Group use laser technology, and they will concur with these points. Further along the pavement, towards Storrington, on the west side of Amberley Road, it narrows to less than a metre. Indeed, I've measured it, it's 90 centimetres. Two adults cannot pass each other. And I walk my dogs 4 times a day, and frequently I have to wait either in somebody's drive to let them by, women, men, whatever. So access is not 2 metres. The longer way does have footpaths, but with overgrown foliage, the footpath is frequently narrowed to less than 1 metre. I would also point out that the police are often just off the top of Newtown Road and the Amberley Road with their speed guns, because they know that this is one of the areas where speeding is prevalent within West Sussex. I'd now like to address road safety. Newtown Road is not wide enough for a school bus to pass a car from the opposite direction, let alone 2 lorries crossing. Last week, a car had legally parked on Newtown Road. The school bus driver had to blow the horn for several minutes to attract the person whose car is parked to get them to move it. Otherwise, they could not pass to drop off the children at their drop-off points. I can imagine the additional chaos that will be caused by 20-ton and maybe more trucks, articulated vehicles that will have an enormous job driving down Newtown Road. But it does not end there. Access to Bats Close is wide enough for a lorry and a car. But as you move down towards the 90-degree bend in Bats Close, off which this development is proposed, a 20-ton truck will have to move out to the right to get round it. Most trucks of 20 tonnes are 3 metres wide without their overtaking mirrors. They will have to drive on the wrong side of the road. Articulated lorries are unlikely to be able to get round unless they go on the pavement or residents' lawns. Most of the residents will have delivery vehicles, visitors who might park there, all within their rights. Their driveways are limited. They are not very long, so they may only have 1 the capability of putting one car on the drive and there are other vehicles on the road. I visited last night and I can confirm that that is the case. Most delivery vehicles, like the dust cart, have to reverse in. Well, that part of Bats Close, I'll estimate, is about 100 yards long. But if the Bats Close extension is agreed, and given there is no proposed turning circle for fire, ambulance, police, Amazon drivers and the like, they will have to drive in, maybe forwards 250 to 300 metres, and then reverse out, or do the opposite. And I hope that they too have sought agreement from our emergency services that this can happen. The junction of Newtown Road and the Amberley Road is almost blind. And I would ask with respect that when you do your site visit, you come out that way. It's a blind rise with low vegetation, which makes pulling out highly risky. I can assure everybody in this room that in the 40 years I've lived there, I have only used that junction twice. It is dangerous. The previous owner of the house on the junction on the left side was a doctor, and she administered care on a number of occasions before paramedics arrived when road traffic accidents had occurred on that junction. Our own postman was shunted into the rear garden of the first house in Downlands, maybe about 2 or 3 years ago. And we've recently had a motorbike crash into a car that was turning right there. Motorbike was overtaken coming out of Storrington. Cars coming from Amberley frequently pass the junction at 60 miles an hour, the national speed limit, before eventually de-accelerating to a more modest speed well past the 30-mile-an-hour zone. I cross that road at least 4 times a day while walking the dogs, and although I take extreme care and with glasses have 20/20 vision and excellent hearing, I've been subjected to a fair number of close calls. And tragically, and it was a while back, a young girl was killed almost opposite the proposed development as she crossed from the wooded side, the far side, along a footpath into the proposed development field. It was some years back. And as I said, police do patrol that just before that junction. My view is don't put profit before safety. If this application is agreed, I think it is imperative that access is provided from the Amberley Road. And I'm willing to escort anybody, planning officer or yourself, on a detailed site visit before judgment is made. Construction traffic coming into Bats Close to build 20 houses, I've no idea how many vehicle movements that would be per day. But it absolutely horrifies me that the amount of traffic that would be not only in Newtown Road, but Bats Close as well. My view, I think the directors of A2 have to put safety totally above profit. Otherwise, they will be responsible for any accidents on that junction. Thank you.
Thank you. And can I just clarify, when you were talking about the space on Bats Close, did you mean where it kind of turns, where you turn left, as if you're heading down towards
So as you come down, you're now on Newtown Road, and whether you turn left or right, you come into Bats Close. At the at the opening, there is adequate room for a lorry and a car. As you move further down, it narrows. And I will assure you, if you get a measure out, it's about 6.4 metres. Bear in mind my comment earlier, and I looked it up on the internet, a 20-tonne vehicle, and that's more likely to be the ones that bring in sand, cement, roof trusses, blah, 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 are 3 metres wide. A car is about 2.4, something like that. Any other lorries that happen to be in that area, well, it will be an absolute nightmare. And then you've got the additional point that people are allowed to park their cars on back slopes on the road. You're going to have lorries just weaving in and out and trying to get into a proposed development or having to reverse in. I mean, it makes absolutely no sense at all. I'm sorry I'm passionate about it, but...
That's fine. I understand your point, so thank you for your contribution. And again, I think we will pick up on some of those issues later today, so feel free to engage in that discussion when we get there. And I will invite anyone that wants to say anything in response to any of those comments later today when we get to the relevant agenda items. So that brings us on to...
Or would I have a chance to talk as well? Or... Thank you.
Apologies.
Thank you very much. So, yes, thank you. My name's Claudia Fisher. I'm the elected ward councillor for Storrington and Washington Ward at Horsham District Council. Today I'm speaking as a ward member, not as Horsham District Council. I'm also speaking on behalf, actually maybe I should have mentioned this earlier, of my fellow ward councillors Emma Beard and Joan Grech, who can't attend today and give their apologies. I can repeat their names if that's useful. So
I think I've got those here.
Okay, great. So they are also acting as ward councillors, not as HDC. I'm also the chair of Storrington Speedwatch Group, and I'm an active operator as part of the Storrington Community Speedwatch Group. I've regularly monitored and measured speeds with a laser speed gun at the very point where Newtown Road and Amberley Road meets. So I don't know the area as well as the residents do, and I bow to the very intricate and detailed knowledge, which I think is very helpful. And I also fully support everything that's been said so far. Just some background, Councillor Beard and I spoke at the Planning Committee on the 19th of August 2025 when this application was heard, but neither Emma nor myself are members of the Planning Committee. Councillor Grech, who was a member of the Planning Committee at that time, was unable to attend, so had her statement read out by an officer. Her absence also meant that she was unable to participate in that meeting. So none of us could do anything more that evening than make a 5-minute statement. We weren't able to challenge incorrect facts, ask questions for clarification, raise concerns with officers, participate in the debate or put forward motions or contribute to the motion that was put forward. So obviously that was quite frustrating, but I am very pleased to say that the committee did listen to our concerns and to the concerns of 163 residents who objected to this development. They refused the application contrary to the officer's recommendation, and that was a right decision. I urge you today to uphold it, and I'd like to explain why. So first of all, the South Downs National Park and wildlife aspects, leaving aside that this rural edge of village site is not included in the parish council's neighbourhood plan, nor is it included in HDC's emerging local plan, nor has it been. My colleague Emma Beard has submitted detailed evidence on the ecological harm. In summary, this site sits immediately adjacent to the South Downs National Park, which starts literally the other side of the Amberley Road. The legal duty under the Levelling Up and Regeneration Acts requires us to seek to further the park's purposes, including wildlife conservation. This development would harm bat corridors, Barbastale bats protected under European law, use the southern boundary vegetation as a commuting route. Loss of mature hedgerows and trees combined with lighting spill would sever that corridor. The dark skies of the International Dark Skies Reserve would be compromised. The development would push artificial light outward into the park setting. Natural heritage would be eroded and a protected oak would die. This is not an abstract point. We've seen communities right across the district rally to protect our natural heritage, specifically some local important oaks, such as the veteran oak known as Oakley under threat in Calfold, and the 3 large oaks fondly known as the Billy sisters under threat in Billingshurst. It's clear that not only do these important aspects of nature matter as elements of ecosystems, but also that people care deeply about protecting these irreplaceable assets and their right to care. My colleague, Councillor Joan Grech, has documented the highways case in detail, so I'd like to summarise the key points. Backs Close is currently a quiet residential cul-de-sac serving just 11 households. The name says what it is, a close or a close, meaning closed to traffic. This development would add 30 households to the end of this close. This means approximately 175 to 180 additional vehicle movements per day through these currently incredibly quiet streets. Add to that the current 31 movements, and we're looking at over 200 vehicles per day. Over a year, that's 64 to 60,000 additional movements through Backs Close, a quiet residential cul-de-sac, and then out into Newtown Road, a narrow residential street, which goes down to just 4.3 metres at its, I hate to say wide, narrow at its narrowest point, where West Sussex County Council recommendation is 5.5 metres. And there are sections which have been mentioned before where the road is narrowest, where no footpath either side exists. I myself have watched people with buggies struggling up the hill in the centre of the road, as that's the only way pedestrians are forced into the road. It's dangerous now. Imagine what it would be like with all of those extra vehicles. And we have traffic data showing this is not an empty concern. I'm also chair of the Storrington Traffic Group. Our community group has been instrumental in getting vehicle activated signs installed throughout the village, acting in conjunction with the parish council, to record traffic data on our local roads and attempt to calm the speeding traffic in the village. The vehicle activated speed signs on Amberley Road, where all this traffic would exit onto after Newtown Road, recorded 960,245 vehicles over 3 months. That is 10,660 vehicles per day. And this is the critical point. 60.3% of westbound traffic exceeded 30 miles an hour. And 29.7 were doing 30 miles an hour or above. So just to recap, the national average for speeding in 30-mile-an-hour zones is 9%. In Storrington, on the Amberley Road, it's over 60% when looking westbound. So this development would be adding 175 to 180 movements per day to a B road where 6 out of 10 vehicles are already speeding, and where there have been, as we've heard, some serious accidents and many more reported and unreported minor ones. And the junction between Newtown Road and Amberley Road is currently so dangerous, many locals, as we've just heard, and I've heard this many times, won't even consider risking it. Instead, they take the long way round, turning left out of Backs Close, along Newtown Road, down Pulborough Road, into the centre where the petrol station is, and out again, rather than braving the speeding traffic entering the village at Amberley Road. Of course, this adds to the terrible traffic congestion that Storrington suffers from, and all the consequences that follow: impact to local businesses, extra noise, inconvenience, and poorer air quality. The construction phase would be worse: 50 to 80 HGV movements per day through narrow residential streets for 12 to 18 months, 18 to 28,000 construction movements over the build period. So let's think about the human impact. This is not just about numbers. It's about the lives of real people. It's about the people who run dementia groups down that road. It's about the people who have grandchildren, who have disabled adult children living with them. The residents of Backs Close and Newtown Road would experience relentless traffic noise, children unable to play in the street, elderly residents struggling to cross their own road, delivery vans and lorries mounting pavements because the road is too narrow, HGVs shaking homes for 18 months during construction. My two fellow ward councillors are not here today, but they have made detailed submissions and their voices need to be heard. Emma Beard's passion for protecting nature and wildlife, and Joan Greck's concern for the everyday safety and well-being of residents. Of course, I share both of these concerns. And I would add, the Planning Committee heard those concerns, took them seriously, they refused this application, and they were right to do so. Now, moving on to the protected oak tree, T2. Having looked at the wider implications, I need to talk just about one tree. Tree Preservation Order TPO 1140 protects 3 mature oak trees on the boundaries of this site, adjacent to Backs Close. Those trees were protected in 2002, that's the better way of saying it, because they were recognised as significant landscape features contributing to the rural character of the area. But today, only one remains healthy. Tree T1 was removed in 2017 because it was in terminal decline. Tree T3 is now dying. The latest inspection shows extensive upper crown dieback and warns that severe intervention is required, and sadly that recovery is highly unlikely. It is heartbreaking to read and to see. So in less than a decade, we have lost 2 of the 3 protected oaks. Tree T2 is now the sole surviving healthy oak. It is a dominant landscape feature. It is specifically protected, and this development would very likely kill it. The appellant claims the access can be constructed through T2's root protection area without harm, using reduced dig methods. They rely on a commercial route survey which says access might be possible in principle if an appropriate design is developed later. But HDC's expert arboricultural officer, Andrew Bush, has examined this evidence carefully. His technical rebuttal is devastating. The survey was incomplete. It only detected roots larger than 20 millimetre and missed the finer roots and fungal networks, which are essential to tree health. It warns that excavation below 100 millimetre depth causes significant harm. Yet standard road construction requires 300 to 500 millimetre excavation. And it's important to note that the site slopes uphill significantly. No dig is not feasible. The Highway Authority won't accept it. Mr. Bush's conclusion is clear. It has not been satisfactorily demonstrated that the proposed access can be implemented without resulting in a high level of harm and a highly likely irreversible decline to retain TPO tree T2. So in plain language, if access is built via Backs Close, T2 will die. Which brings me to the elephant in the room. There is a better way which has not been properly explored by the appellant, and that is direct access from Amberley Road. It's interesting to note, and I have heard this from several residents, who I'm sure would be prepared to testify, but unfortunately aren't able to be here, that at a public meeting, the developers themselves told residents that construction traffic could access the site via Amberley Road. No? I thought it's back again. Yeah, okay. Thank you. If the developers were true to their promise made to Backs Close residents at that meeting, which is at the Crown Inn pub held a year or 2 back, ensuring construction access via the Amberley Road, then why have they not proposed using Amberley Road for all access? Using Amberley Road as both construction and residential access would make such a difference that I'm actually at a loss to understand why we don't have an application before us using that access plan instead of this totally unworkable one. If it's feasible for construction, why is it not feasible for permanent access, and why has it not been explored further? Recognising the need for extra housing, this alternative would solve many of the issues associated with this application. It would avoid harm to protected tree T2. It would eliminate traffic through narrow residential streets. It would provide safer pedestrian routes to the village for new residents who would just have to walk down Amberley Road, and it would keep construction traffic away from existing homes. This, in my view, and many others, is a fundamental omission. So, looking at the planning balance, the appellant argues that the housing need engages the tilted balance and the benefits outweigh the harms. But the planning committee did not agree. And there are good reasons why. Protected oak T2 is at risk. The alternative access has not been explored. Wildlife and dark skies protection has been inadequate. Highway safety concerns are genuine and documented. The existing residents' rights to safe and peaceful homes matter, as does the undeniable benefit to the local community that this much loved field provides currently. And perhaps most importantly, none of this complexity goes away if you approve this appeal. These harms remain real, these concerns remain valid, the alternative access remains available. The Planning Committee refused this application on grounds of harm to landscape trees and Southlands National Park. I would argue that some of the other issues were not fully examined at that hearing, partly due to the way it was, the Constitution is arranged, meaning that we weren't able to engage further. So I urge you to uphold that refusal. I ask you to dismiss this appeal and ask the developers to consider bringing back an amended plan with different arrangements from Amberley Road, with calming measures, continuous safe pedestrian routes and a binding construction traffic management plan. We believe the right decision is to dismiss. 3 ward councillors representing thousands of residents stand together in opposition with residents and the parish council in opposition to this appeal. We're not anti-development. We know we need housing. Instead, we're pro-communities, pro-safety, pro-protecting the natural heritage that defines this area. The Planning Committee got this right. Please uphold this decision. Thank you.
Thank you. Okay, so I think that is now all the pre-prepared statements, isn't it? Thank you. And that brings us on to number 3 on the agenda, which is the main issue. Just to start with, there are no policies referenced on the decision notice. I note from the council statement that there's reference to policies 25 and 33 of the district planning framework. Are those the policies that are relevant, and are they the only policies that are relevant?
Yeah, so you could also add policy 30. Okay,
thank you. Mr. Watson, do you want to say anything?
No, thank you.
And then before we start looking at the effects of the proposal, I'd like to just look at the site and the area as it exists now. So if we can just kind of park the proposal in our minds just for the time being. So I'd like to start by coming to the council, if that's okay. Can you just describe to me what are the key features of the site and its surroundings that contribute to the landscape and the visual character of the area as it exists now?
The appeal site extends to around 2 hectares and comprises of 2 fields together with perimeter vegetation situated to the south and southwest of the defined built-up area boundary of Storrington. The site is publicly accessible by way of a pedestrian gates from Newtown Road, which provides access to the public right-of-way, which passes through the site at its northern extent. 2 trees situated at the northern extent of the site adjacent to Backs Close are subject to TPO reference 1140, with the site additionally adjacent to the Grade 2 listed building of Cobb Court. The site sits opposite the South Downs National Park, which extends to the southern side of Amberley Road in this location.
Thank you. So just, I mean, in terms of the trees on the site, and in particular tree T2, how important are those features to the sort of landscape and visual character I sense Mr.
If I may, ma'am. So essentially, as most people in the room are aware, a TPO is a landscape-based designation. It's intended to preserve trees of high public amenity value. The tree T2 is readily visible from Backs Close itself, and also from users of the public footpath, which passes it to the south. As such, given that it is the sole remaining healthy specimen within the previously 3 protected trees at the site, its landscape importance is further heightened, being given that the other 2 have unfortunately succumbed to issues, and one of them's obviously been removed, and the other one its removal is inevitable, which further heightens the importance of tree 2 as an individual landscape feature, whereas previously it contributed to a belt of trees, whereas now, as I said, it is the principal arboricultural feature within the site and within the main areas of public visibility from Backs Close and from the public right of way. I mean, there is additional trees within the site, including the belt along the southern boundary, some of which is going to be removed should the scheme be approved. From a purely arboricultural perspective, the quality of the trees in this area is not the same as the TPO tree to which we've been referring to. As such, the primary arboricultural concerns relating to landscape are that of the impact on tree T2.
Thank you. You just answered one of my later questions, so it's helpful. Thank you. And then if I can come to who wants to take this one. So if you want me to repeat my question, it's just what are the key features of the site and the surroundings that contribute to the landscape and visual character? And there was a second question, which was how important are the trees on the site to that character?
Thank you, Madam. I think Mr. Pratt will also have comments on this as well. But I think initially from a landscape perspective, I think it's important to note that the features that were just described in relation to the trees bounding the site, particularly to the northern and southern boundaries, which you'll have seen on your site visit, enclosing the site, are part of the wider character of the area, which you'll have seen is within the character area E1, which is the Parnham, Storrington, Wooded Farmlands and Heaths, which is the published landscape character assessment character area. And these wooded oak hedgerows are distinctive features in the landscape as a boundary feature around the site. Similarly, along Amersham Road, we have the boundary of the sites formed by mature trees along the road, and then younger trees on the inside of that, providing enclosure. And as set out within the RVIA, which, Madam, you'll have seen, there are other features on the site, including the watercourse along the northwestern boundary. And then there's dividing copse of woodland that goes east-west across the site as well. And those features all contribute to enclosing the site on the edge of Storrington within the wider landscape. In relation to your second question, relating to T2 particularly, I think, having known that you've been to the site, it's useful to know that you've walked the footpath as well. You'll have seen, particularly on that northern edge and extending beyond the site, when you look from, I think it's viewpoint 5 in the LVIA, you can see that feature of the mature oak trees across that boundary, which are prevalent within the landscape, and a dominant feature of which there are plenty of mature trees, including a veteran tree, which is along the site boundary, which is not within the TPO, but it's along the northern edge of the site, which is obviously of historic value and ecological value in its own right. And these are, in my opinion, the dominant features within the landscape. So T2 is a tree which is separated from that tree abut adjacent to the built edge within the site, and makes a more limited contribution to the character across the area and the site itself.
Madam, can I just pick up a couple of points in it from a sort of policy perspective before I just ask Mr. Pratt to come in on the sort of more arboricultural importance of T2, please? So as you just heard, our position is that and you've already been for a look around, there are very many oak trees, specifically oak trees. There are lots of those, you'll have noticed from what you've already seen, of similar quality in the vicinity. And I would ask you on the site visit to note that, and in particular, I know from my own visit that there are obvious examples in the vicinity of the site of, large trees right next to existing accesses. So that's something I just ask you to have a look at when you do the site visit. But what I just want to emphasise from a policy and legislation perspective is our case is that the TPO came about because there was a fear, I think, when Backs Close was constructed, that the house that's next to what was originally 3 TPO trees, might impact on that. And so that's why that TPO came about. It wasn't that somebody went along one day and just thought to themselves, these 3 trees are so significant in terms of amenity or what have you, that we should just have a TPO. It was a response to a perceived concern about the impacts of that house being constructed. And also, I'll let Mr. Pratt speak to this in more detail, but the T2 is not a veteran tree. It's not even in arboricultural terms category A, it's category B. So those are all points I'd like you just to note that I might refer back to when I kind of bring the appellant's case together in summary and we come on to the overall planning balance. But yeah, I just ask Mr. Pratt if he had anything to add specifically on your second question about the tree.
Thank you. Morning, Madam. So from an arboricultural perspective, I'll just give you my opinions on the key features of the site from arboriculturally. So most of it derives from a sort of collective merit of the tree cover, particularly along the western boundary. We've got several mature oak trees along that boundary, along with kind of understory vegetation and other sort of smaller trees as well. It's very strong, continuous, well vegetated boundary. Along the south, along Amberley Road, there's an important distinction between the trees that are directly along Amberley Road and those that are the more recent planting that we see inside the site. The trees that are aligning Amberley Road are mature. A number of those are category A under BS 5837. Several of those are also mature oak trees as well. Internally within the site, Mr. Hughes referred to the small copse. That's referenced as G17 in the survey. That's a relatively young planted group, but it has some collective merit as a collective feature. But individually, those trees aren't of particular value. In relation to T2, highlighting that classification of trees is subjective, but ultimately this tree, in terms of its scale, its size, was considered by the surveyor as a moderate value tree, and it has moderate kind of contribution towards the wider landscape and or the local kind of context. It's not a high value feature in the sense that it contributes to that continuous belt along the western boundary, which is a key feature that Mr. Hughes had referred to. It's more isolated in that respect. I think that along the eastern boundary, the northern part of that, we've got a series of sort of lower to moderate value trees that are probably, have been planted, so they're more sort of immediate planted trees that have matured, so some horse chestnut, some sycamore, so it's sort of less in keeping with the wider kind of context of the other boundaries in terms of species and composition. Yeah, that's how I describe the kind of overall composition of the site.
Thank you, and I will come back to you in a moment, but just in terms of the, staying with tree T2 particularly, in terms of its, you've sort of mentioned that it's, in your view, of moderate value, it's not category A and it's not a veteran tree. If you were to describe its sort of current condition and its likely lifespan and its health without the development in place, how would you describe that?
I describe that as good. There doesn't appear to be any physiological issues with the tree, as far as I can see. That there is some evidence of past management in the tree, which is worth noting, but it's responded to that well. Generally, the tree is in good condition.
So it's likely lifespan.
There's a golden question with trees. An oak tree can live up to sort of, between up to 500 years old in exceptional or even 800 in exceptional circumstances. But for this tree, this could live on for another 100 years potentially. That would be my very rough estimate.
Mr. Bush, would you like to say anything in response to any of those?
Yeah, just a couple of points really. First of all was with regards to the point raised about the circumstances to which the TPO arose in response to the adjacent development, and the point that was made that someone didn't just come along and put a TPO on the tree. I mean, essentially a TPO is a legal designation. It's only meant to be used when a tree is considered to be under threat. As such, the premise behind serving the TPO was based on the perceived threat from the change of use of the land to the north of it, turning from open field to residential use. That was the sort of perception behind why the TPO was put in place, rather than people just walking around and putting TPOs upon trees, as was kind of alluded. The second point, don't dispute the collective value of the other trees around the edge, which as a group do make a positive contribution to their landscape setting. I think the point regarding T2 is that it is an isolated feature at the entrance towards the proposed entrance to the site. So essentially it would become, should the scheme be approved, a sort of gateway specimen mark denoting the entrance to the entrance to the site, which further sort of bigs up its sort of landscape significance. It's the first thing that you would see. And when you turn the corner into Backs Close, again, it is the first thing that you see as you look down the road.
Thank you. And then in terms of just where tree T2 is kind of visible within the landscape, I heard earlier that it's visible from Backs Close and also from the footpath that runs through the site. Are there any other particular public vantage points that tree is kind of visible from?
Not that I'm aware of, due to the built form of the dwellings to the east of the site. Views of the tree from that aspect are obscured. And given the absence of any sort of significant public footways on the Amberley Road and the existing boundary vegetation, views from Amberley Road, you may catch a glimpse of the top if you're sort of looking in that direction in winter, but the primary viewpoints of the tree are from within Backs Close and from the well-trodden public footpath that is located due south of it.
Thank you, Madam. Yes, I think I agree that the tree beyond those immediate views is not easily discernible. You'll have noticed when you walk the footpath that it does blend in behind these mature trees to the boundaries, many of which are larger than this tree, and create that oak hedgerow boundary feature. Within some of the wider views, the useful references are the views actually from the escarped slope that are contained in the LVIA, which are viewpoints 1 to 3. I don't know if you've visited those views at all, or you've seen the photos that we have of them.
I drove up the road yesterday, but it was torrential rain, so I will admit that I thought I'd delay that until after the hearing, but I will be visiting those viewpoints. Yeah.
I think we might talk about them a few times today. We do have, I think, hard copies of them printed out for you there as well. But I would point in those wider views, the particular tree is not discernible amongst the wider views across the edge of Storrington, which is well treed and also has internal trees throughout the settlement. So it's very much a limited feature in local views.
Ms Fisher?
Just wondering if it's possible to add a couple of things. Thank you. So we've heard from the appellants that the tree T2 is of moderate value in its contribution to landscape. I would, because of its the fact that it's on its own and not part of a group, I would say that actually adds to its value, because what it does is it's a standalone feature. As Mr Bush says, it's actually a gateway, it's much loved, and it is very healthy, and it could last many hundreds of years going forwards. I think that's important to note. And so it's a little bit like when people say you can't see the wood for the trees. This one you can definitely see. And it's really important to residents and to walkers and the people of Storrington.
Thank you.
Thank you, Madam. I just wanted to add to the concept of the sort of three have become one point that's been raised. It is very, as Mr Bush alluded to, it's very important to understand the context in which that TPO was served. That TPO was served to protect those that were under threat from the developed site of Backs Close. That TPO was not served to identify particular trees that were unique in this landscape. Therefore, the suggestion that it should be afforded elevated weight, that it is the last remaining healthy oak, isn't supported by that wider context, because there are lots of other oak trees within this setting that will be retained, that will stay there. It's not the only healthy remaining oak tree in the area.
Thank you. I think I've understood all those points now. Is that noise something? It's just, it might be the air conditioning or something.
It's probably air conditioning. Also, I know there's work in the kitchen today, so it doesn't sound like it's coming from there, but it could be.
See if it finishes, but everyone can hear okay still. Hopefully it's not disturbing anyone too much.
Sorry, Mum, I think it sounds like it is going, but I'm finding it quite annoying, and I was struggling to hear people anyway. So I don't, if it carries on, I don't know if we can switch the aircon off for a minute or so. But anyway, just to, I think
like
it sounds like it has gone actually.
It's gone for now. So should we see if it happens again, and then maybe at the break, if you can just double check what that is that okay? Okay, so again, just staying with the existing site. I'd like to hear some views about how far the existing site contributes to the special qualities and natural beauty of the South Downs National Park. So can I come to, I don't mind who, but from the council first on that, please.
So in line with previous appeal decisions on the sites, and as addressed in the committee report, the site is identified as positively contributing to the appearance of the surroundings and the rural character of land beyond the edge of the settlement of Storrington more generally. The introduction of housing to the site, together with all of the associated access, parking, street lighting, fencing, pumping station, etc., would significantly alter its existing unspoilt character. The proposals would lead to the effective loss of pasture, to a notable loss of openness, and introduce far greater urbanising effects above those that the site is currently exposed to.
Sorry, just to pause there. I just want to look at the existing site at the moment.
sorry.
We will come on to look at the proposal, but it's just understanding. I don't want to sort of infer from what you've said, but what does the site contribute at the moment to the sort of landscape setting in the national park?
So the site at the moment acts as a landscape buffer between the built-up area boundary of Storrington and the South Downs National Park, which is then separated by the road, and then it's immediately the national park. So it is an open area of land that acts as a buffer, which is not urbanised, it is countryside.
Thank you, and I will come to you in a moment. But just in terms of the existing built-up sort of edge of Storrington, what effect does that have on this particular part of the setting of the national park?
So I think that the boundary of the built-up area, this is then the buffer before the South Downs National Park, so it retains the openness required to protect the South Downs National Park from the urbanising features of a development.
Thank you. So again, the same question over here, please. So how far does the site contribute to the special qualities and natural beauty of the South Downs National Park?
Thank you, Madam. I think you have seen the quite extensive amount of work that's been done as part of the application on this, not to mention the Appendix 6 of the LVIA, which talks about setting. It is more looking at the impact on the setting that it does to provide a lot of information about the special qualities of the national park and the purposes for its designation. I think, first of all, just addressing the point about the buffer, there's no necessary requirement for a buffer to the national park. And I think from your second question about the existing built edge, as you're aware, to the east of the site, the edge of Storrington adjoins the boundary of the national park with rear gardens fronting onto fields. So that highlights that boundary is very much in that location, wrapping around the edge of the settlement. The site obviously falls outside of the national park. It was assessed against the natural beauty criteria, which are the statutory criteria for designations. So the site does not meet those sort of natural beauty criteria and isn't a valued landscape within the designation in itself. The boundary vegetation, I think we were talking about Amberley Road as being the boundary. At the moment, the character of Amberley Road is a very well-treed road with the boundary of the national park on the southeastern southern side. And that's the character of that particular boundary in that location. So the site with the wooded edge to that forms that edge as we have it. To the west, the boundary is beyond the agricultural fields up to Clay Lane, which is the edge that extends then further to the west. So the site forms part of an area on the edge of Storrington, which is outside of the national park. I think in terms of the wider setting, again, a lot of it's to do with these wider views that I mentioned with you earlier. Storrington is a settlement within these wider expansive views from the higher ground, which are one of the special qualities of the national park. The site makes very little contribution to these views. It's barely discernible, contained within that woodland edge, and the whole settlement is set within those wider views. And so in relation to that wider setting point, I think the site makes a very limited contribution. And then finally on that point, sorry, I'm just the setting looking back towards the national park. And again, that viewpoint 5, the views that you went when you went along the right of way outside the site, you get clear views across the open fields and lower-lying landscape towards the scarp and the hills as a backdrop. Whereas when you're within the site, those views are largely screened by the trees and hedgerows surrounding the site, which you'll have seen as well. So obviously makes a more limited contribution in that respect as well.
Thank you. I'll just come to the council first if there's anything you'd like to say, and then I can see that Ms Fisher wants to contribute. Okay, thank you. Ms Fisher.
So I just wanted to add that this isn't about views from the South Downs National Park. It's about connection, it's about ending, it's about what matters to the people who live in Storrington, which is a really important, it's surrounded by sites of special interest. It's got the Arun Valley Ramsar site, Pulborough Wellbrooks as well, all sorts of incredibly important ecological features here. And it's about perception as well. It's about sprawl. It's about when you drive out of Storrington. One of the reasons people put their foot down when they're on their way to Amberley on the Amberley Road is because they feel they're out of the village. It's about respecting the neighbourhood plan, where this is not included and also not part of it's outside the built-up area boundary. In terms of what it matters to people, we've heard from Murray Chisholm about the importance of being able to walk on those fields, the massive outcry on Facebook when those signs went up only a couple of weeks ago saying private property keep off, because there are well-trodden footpaths. I've heard speak of glowworms and nightingales, all sorts of importance, badgers. These are important pieces of ecological information, and nature doesn't live to boundaries. It doesn't know that there's a road and that's where the South Downs National Park starts and where it doesn't. It's not about how pretty it looks from when you go up on a hill. It's about the hills that are surrounding Storrington and how that matters to people as well. So I'd say it's of highly significant importance to the people of Storrington and to the ecological and nature of Storrington and the South Downs National Park, because it provides a very important buffer.
Thank you. And
sorry, Madam, can I just respond to that, please? So just, there was a reference in passing to sprawl. The council's position at 3.5 of their statement of case, I just point out, is that they acknowledge that the visual impacts to and from the national park are limited because the boundaries to the site are well screened and treed. And then on Councillor Fisher's more general point about the value of the site, to local people, I mean, those considerations are taken into account in an analysis of whether a site is or isn't valued landscape. So there's the Landscape Institute's technical guidance note that deals with this, and there are various criteria, but they do acknowledge, the value that a site may have to the people who use it. And the agreed position between the appellant and the council is that the site isn't a valued landscape in those terms. So for the purposes of applying paragraph 187A of the NPPF. So I don't think it would be right to suggest that the value of the site to people who use it on an informal basis, I should add, has been overlooked, because it hasn't been. It's something that does factor into the analysis that the appellant's undertaken of the value of the site in landscape terms.
Okay, thank you. I think I understand what both of you are saying there. I did have this question a bit later, but seeing as we're touching on it now, I would like to understand what the arrangement is for public access to the site. I've read lots about informal access having been, and heard about it having been the case for many decades. Can you just sort of explain to me what the current arrangement is, and how long that's likely to endure?
Yeah, I guess I can say that there is no kind of expressly permitted public access, with the exception of the public right of way. I appreciate that the signs have been added probably at the wrong time from a kind of public perspective, and we didn't intend to give the impression that that has always been the case. I completely appreciate that there haven't been signs up until recently. And yes, there is ability to access the site from the public right of way, but it isn't kind of expressly allowed.
Madam, just to add from a sort of legal position, we acknowledge obviously informal use of the site is made by the public. We don't dispute that at all, but in legal terms, that remains informal. Now, I hear from what the third parties have said that it's their view that they have been using it for long enough. I think the point's being made is that if they, it could be, it may be that there is an established right of user. The point on that is that that's not a matter for you, madam. There's a separate process that would need to be explored to get to the bottom of that. And so for the purposes of you determining the appeal, the legal position is that there's a public right of way, and then in legal terms that we accept there is informal use made, but that doesn't have any sort of specific legal status.
Thank you.
If I can make a point that when Vax Close was built, a few years after, and I can't remember how many, but I think certainly about 20, whoever owned that field, the development field, put a fence all the way around it. But within that fence were 3 access points. One off the footpath next to the oak tree, a further one where unfortunately that young girl was killed crossing the road. I'm not sure how to describe it, but the far end away from Vax Close. And a further one almost next to Newtown Road, Amberley Road Junction. And it was a fairly substantial fence and gates all the way through, almost implying come and use the field. And I can't remember if it was annually or biannually, somebody would come and clear the field of all vegetation. And the vegetation I'm talking about, brambles and the like. So I think from a perspective of the local, it was very much considered to be an invite, not official, not unofficial, to use that field for amenities, and principally, let's say, dog walking. So a lot of people would walk through from the footpath, the opposite side of the Amberley Road, down the footpath through the woods, across the road, into the field, and then out towards Horsham, past the pig field. And conversely, also coming from Horsham, through the footpath, open the gate, go the other side, and come out onto the Amberley Road, where there was no footpath, but there was a gate. And I think the fact that it wasn't sealed off, that there were 3 access points, gave the absolute impression to the locals that this was enjoy the field as an amenity. And therefore I think there was quite a lot of disgust when the sign went up a fortnight ago, whatever it was, saying private property keep out. That was very contrary. The ownership hadn't changed. The field remained the same. I have to say the fences over those, let's say, 20 years, some of which have come into disrepair, but suddenly a sign goes up saying keep out. It was not well received. Thank you.
Thank you. Okay, so we can look at the proposal now. And I just want to, first of all, start with looking at trees. I do have a few questions here. So, I've already had that one answered. So in terms, I mean, obviously I've heard and read a lot about the potential other access routes to the site, including from Amberley Road. And that's obviously relevant in terms of the incursion into the root protection area of Tree 2. Is this a case where construction within the root protection area is unavoidable?
In my view, yes. And that is key to the case. The access along Amberley Road was explored during the design process of the application. It hasn't been overlooked. And I was asked by the appellant to assess the impact of an access from Amberley Road and the associated tree loss that would occur with an access from Amberley Road is far greater than that that is alleged to potentially occur from Backs Close. I do have some figures in front of me that I'm happy to talk you through in terms of the extent of loss, but I appreciate that wasn't part of the evidence.
Yeah, I think it's more just generally trying to understand whether that was explored and how far it was explored. So I think you've probably answered that question and why it was discounted. So
Okay,
I understand that. Thank you. Anything that you'd like to say on that?
No, I don't think so at this point.
I don't mind who goes first.
Sorry to interrupt. The possible access from the Amberley Road, I would point out that the original field had a gate there that is probably 8 to 9 feet wide. So to infer that trees would be damaged or whatever, there is a 9 foot, well, call it 3 metre access there, and that gate is still there. So it's not as if it's a little narrow 1 metre gate. There are no trees in the way. There may be brambles, but if we went back several decades when that field was probably used for agriculture, there was a proper, I don't know how to describe it, but big gate in that access. So to say that trees would be knocked down, partly true, but not as big as you would expect. Thank you.
And will I be able to see that gate when I'm on site?
If I was to escort you there, yes. But I have to say we have to go through a bit of bramble and what have you. And I am available either this afternoon or tomorrow.
Okay, thank you.
Yes, I just wanted to add that we have looked at that. There is an area which wouldn't, obviously the argument is going to be, well, you have to cut one tree down or lots of trees down. And so it's kind of, you know, it's a no-brainer that we would do the one. But actually there is a section, as Marie says, and I think I understand that that's where the gas pipe goes in as well. So there is already, so there might be some saplings that have grown up there, but we're not talking about cutting down mature trees. And obviously it would be much more expensive to have to create a new road off Amberley Road, and I understand why the developers wouldn't want to do that, but it is an option, and we don't believe it's been fully explored.
Thank you.
Madam, I am going to ask Mr. Pratt to just give you some more detail on exactly what the extent of the loss would be on the Amberley Road entrance, acknowledging that it's, yeah, our case is not that it's simply a question of is it one tree versus many trees, but obviously, you know, there would theoretically, I suppose, be financial considerations. I'm not sure, there's no evidence before you on that. But from an ecology perspective as well, you know, we're talking about not just a single tree, but sort of a connectivity issue around removing, you know, a line, really, I think. So, yeah, I would, in view of what the third parties have just told you, I do want to ask Mr. Pratt just to give you a better understanding so that when you're on site looking at the, I think it said have been a former agricultural gate, you can understand actually what we would have to do, because clearly an agricultural gate, for a field gate for agricultural use, that can be quite small, but we would need a proper, obviously, residential access appropriate to, you know, have people driving in and out. So it's not just going to be the case that we could punt that through the previously existing gate. But anyway, I'll let Mr. Pratt come in. Thank you.
That's fine. I mean, I don't want to spend too long on this because clearly my job is to determine the appeal that's before me, but it's just in terms of whether this, whether it's unavoidable to construct within the root protection area of Treaty 2.
Yeah, so the reason why the loss of trees is greater along Amberley Road, the option of access that I assessed that was prepared by Mr. Hanks requires the widening of Amberley Road. Trees that are along Amberley Road are very, very close to the existing road. So when you widen the road towards those trees, there is no option other than to sever routes all the way along Amberley Road. It's not just a case of having a single puncture point. The road's got to be widened to accommodate the widths required for transport. We also have to consider visibility displays that are required at the entrance, and they will cut through the stems of trees along Amberley Road, which requires loss. We're also talking about, well, the option that I reviewed, we had 3 individual category A trees that would require removal, and they are, according to BS 537, of greater value than T2. We had 4 trees within the category A group that had to be removed, 1 category B tree, 3 category C trees, and approximately 140 metres of hedgerow that needs to be removed from Amberley Road.
Thank you. Quickly, I don't want to spend too long on this, but I'm happy to hear your point.
No, I totally understand. So it's Mr. Pratt, is that right? Was talking about the option that he reviewed. To me, that flags up that not all options were reviewed, and I would really like to be able to just ask, why were several residents at the meeting at the Crown Inn told that construction traffic would be coming via the Amberley Road if there wasn't an access point? So, and I have people who would testify to that as being what they were told by A2 Dominion.
Thank you. Can I just suggest that you pick that up outside of the hearing, because I think that's not necessarily something that I need to be concerned with. Thank you. And then I just, sorry, did you want to say anything on?
I don't think we've got anything in particular to say on the proposed access of Amberley Road. I mean, as you pointed out, it's not really a matter of for you to consider as such at the moment, is it? It's not the case before you.
Okay, thank you. So just looking at the route survey now, I guess just very briefly, can I ask, can you just sort of talk me through what the route survey tells me about the likely effects of the proposal on Treaty 2?
Thank you. So the tree radar investigation is typically undertaken to inform what impact something may have on a root protection area. So it gives us an idea as to the location, depths, and distribution and densities of roots within from trees. Due to access restrictions, we were only able to cover the area for the proposed access road. But I'll just refer to my notes on the sort of key findings. So the radar assessment suggests that the section of RPA affected by the proposed access has been subject to historical disturbance at both the northern and southern sides of the assessment, because they had a fence that they had to get around. We feel that disturbance is likely to be from the construction of the turning head from Bats Close, and the general development north of the tree, but also there is a gas main running through the root protection area of this tree very close to the stem of the tree. So those elements that we know are present and have happened, the radar assessment suggests that's the case, and it picked that up from like reflectors, so things like metals and things like that typically aren't seen with a more optimal soil environment for a tree, so it's considered suboptimal. No surface roots were identified, and there was limited routing within the top sort of 200 mil of the routing area. The overall density of roots appears low in the sort of main area of the proposed access. The density of routing is high at the side of the access, but the access is not proposed on the location where the density is high. Yeah, hopefully that helps.
And can you just sort of explain to me what's the relevance of the root density to the effect on the tree?
So the density of roots, obviously the more rooting in that area, the more sort of nutrient uptake it may have. The denser the roots, the more the tree is relying on that to function. If there is a low density, it would suggest that that area doesn't provide such nutrients and water uptake to support the tree. So higher density means supports the tree, lower density, less significant in terms of supporting the tree's function.
Thank you, Mr. Bush.
Hi there. So, I mean, there's one particular point within the route radar report that I would like to highlight, paragraph 5.7, where it advises, with no routing over 20 millimetres in diameter within the upper 10 centimetres of soil, the removal of turf layers would be possible without significant impact upon the tree. Though excavations deeper than this are likely to have a significantly detrimental impact upon the tree's stability, health and long-term retention, which I feel, given the findings that roots are within the area found that was surveyed, and then that sort of statement on top sort of alludes that the roots are there. Any excavations below 10 centimetres in depth are likely to encounter roots, and if any of them roots are severed, it would significantly detrimentally impact the health of the tree. I mean, that's the information that the appellants have provided themselves, which, given the proposals due to the land levels, are likely to require excavations in excess of 10 centimetres, on the balance of probabilities, you are going to encounter significant rooting in them areas. And as the report says, going below that 10 centimetre depth will have a significant impact upon the tree. So I believe the issue here, or the main arboricultural problem, is with the method of construction not being deliverable due to the land levels. The appellants claim that it can be delivered as a minimal dig or no dig surface, does not align with the topography of the site, essentially. I mean, the curbstone itself is 15 centimetres in height from the Backs Close tie-in. So that means that you need to go below that 10 centimetre threshold where the route survey has identified significant rooting to achieve that tie-in. So it doesn't add up, essentially. You can't go below that 10 centimetres without encountering roots. The curbstone's 15 centimetres, so you need to go below that 10 centimetres to get that tie-in, essentially, is the council's primary concern with the way in which the access is proposed and the impact on tree T2. It's not deliverable as proposed.
Thank you, I understand that. And that sort of brings me on to, so there's a plan of a cross-section provided, I think it's Appendix 2 of Appendix F of the appellant's statement, I believe. Can I ask, what does this show me?
Yeah, no problem. So this is a standard specification for what is referred to as a no-dig construction. I'm just going to find the drawing. There it is. So it's a drawing from a company called Geosynthetics, who specialise in producing cellular confinement surfacing. So a cellular confinement surface is a means to lay a subbase that prevents compaction, allows water to go through the surface, and allows gaseous exchange functions to remain and to occur. It's a solution to putting surfaces within root protection areas. It's a recognised solution to doing that. What it shows is a build-up over the existing ground levels. It has allowed for a 100mm strip of the top turf layer, from which the confinement system will be laid. It then gets filled with the no-fines gravel, and then the top surface layer, which would be subject to detailed plans, would then go on top of that. So what just to be transparent, it doesn't account for what is a level change in that turning head and in that slope that Mr. Bush is referring to, but it's important that we can ramp over the slope. Mr. Hanks will be helpfully be able to talk over that in a bit more detail, but it's possible for us to overcome the slope that's in the turning head. We can still build over that and it still be in line with transport standards. There's not a need to excavate any further than 100mm.
I would like to hear more about that,
Yes.
because as I see, this is a clear point of disagreement in terms of whether this no dig or reduced dig solution would be deliverable. So I've heard Mr. Bush's evidence on that. I'd like to understand how that would be deliverable, taking into account the slope.
Yeah.
I'm going to ask Mr. Hanks to respond, because he's been thinking about this from as Mr. Pratt said, the sort of transport standards for you. So if I ask Mr. Hanks to go, and then if there's anything Mr. Pratt needs to add, he can come back in. Thank you.
Thank you. So I've had a look at the levels based on topographical survey data for the end of Bats Close and the access as it would go into the site. And what we looked at is raising the levels on Bats Close at its southern end, and how far that's possible before you get to the grass, essentially past the curb at the end. And you can raise the levels so they still work with the driveway of the nearest house, and meet highway standards, and then go up towards the site southbound at a gradient of 1 in 12, which is the maximum permitted. That's for an adoptable highway, and this doesn't necessarily need to be adoptable, the access into the site. But even using adoptable standards, you can then ramp up at that 1 in 12 from that point of essentially the south side of the driveway, and then straight across, and you get to a point where you're 22.5 centimetres above existing ground level at the highest point in the RPA. There's a slight regrade we've looked at from the northern side of that property's driveway at about 1 in 50, where it's 1 in 70 at the moment, so a very small difference, and then you transition up from there. I've put together a long section and a plan showing how that would work on a markup on Google Street Maps photo to show it also. I'm very comfortable that can be delivered above the, with enough clearance above the existing ground level to provide for the makeup that you've seen in that drawing there.
So, sorry, just to understand what you said correctly, you'd raise the level of Backs Close?
Yes, there is Section 278 agreement, which will be required anyway to tie into the Backs Close. You can just raise the levels in the first sort of 5 to 10 metres. You could even, over that turning head, you could simply turn it into a nice block paved raised junction, if you like, which raises everything up straight away by 125mm. And then from that point you go up. So there's a number of different ways it could be achieved, either through just localised regrading across the end section, or you could turn the whole sort of turning head area, if you like, the last 15 metres of the close into a raised junction, if you like, in a very standard form, and then just go up from there.
And is that, I will come to you in a moment, is that works that would that be within the red line, or is that works that are
Section
required?
278 works on the public highway, so that it's not in the red line. The Section 278 highway works. That's not unusual for 278 works to be outside the red line, just as the improvements on the Newtown Road and Amberley Road junction are outside the red line.
I mean, certainly, unless I've missed it somewhere, this is the first I've read any or heard anything about
Yes, we've
alterations being made to
I've
Backs
only been able
Close.
to look, after look at this fairly recently, just to confirm that what we've expected was possible is possible. And yeah, so I do have a plan, but it hasn't been submitted because it was too late to submit.
Okay, so just so I can be clear, is that the only way that a no dig or reduced dig solution could be delivered here?
Yes, in terms of section 278 highway works to the end of Backs Close, and then grading up at 1 in 12, which is adoptable standard.
Okay, thank you. Mr. Bush?
Just 2 points. Obviously, as the colleague over there is made aware, Backs Close is an adopted highway under the ownership of West Sussex County Council Highways Authority. So it would be down to them to determine whether they were willing to accept this proposal. And furthermore, as the RPA is plotted within all the documents provided, this would require additional works within the trees RPA as specified on the plans that are outside of the scope of what was already proposed. And the building up of the land levels and the excavations and the tie-in probably would be quite substantial in my opinion. So that is also another consideration, as that obviously doesn't necessarily fall part of the application, but has the capacity to negatively impact the tree as a result of the development with the access as proposed.
Sorry, just to confirm, it would all be building up within the existing construction depth of Backs Close, nothing below the existing construction depth.
Thank you. And just to your knowledge, is this something that the council, either the district council or the county councillor's highway authority, have considered?
We're unaware. I mean, this is the first that we've heard of this proposal.
Madam, on that, the reason this, we weren't actually able to produce, additional written material on this is because the council only really kind of crystallised this point in there. So this is statement in paragraph 3.19 in their statement of case, where they say that following the lodging of the appeal and in response to our case, their tree officer, I think it might have been Mr. Bush, provides a tree rebuttal, and then that's what says it hasn't been demonstrated that existing site levels would accommodate a minimal dig or a no dig construction methodology. So we've obviously then given consideration to specifically this question of site levels, but I think it's, from our perspective, that isn't a point, because obviously it was recommended for approval, so this isn't a point that comes out of the officer report. I don't think so. That's why, we are where we are in terms of the actual documents that are in front of you.
Okay, I understand that. I mean, I think it's quite clear from the reason for refusal that there were concerns on the protected tree, but I hear what you say.
Yeah, I'm not, obviously we've known that there were concerns around the tree, but I think this specific point about there being an apparently, the council says, insurmountable site level difference, I think that aspect has only emerged during the appeal really, rather than something that was articulated earlier on. Thank you.
Thank you. I can see a couple of hands up. I am conscious of time, so I will hear these points, but I think I was hoping to have got a little bit further through my questions, but I think it probably is approaching break time. So I've got 2 hands up, I think. So if I hear those points, and then I suggest we go for a break. So I'll come to
I was just going to say that in the committee report, that paragraph 6.82, we do talk about the council's arborist considers that the tree would be significantly detrimentally impacted by the proposals and that no dig engineering is unlikely to prove feasible given the changes in levels between the site and Backs Close. So it is a point that we did raise previously.
Thank you.
Yeah, I just wanted to pick up a point about the route density that Mr. Pratt was alluding to. My understanding was there was an area of low density, and that was the area nearer the proposed construction and perhaps was going to be more disrupted, with an area of high density that would perhaps protect the tree. But you could argue that the low density often indicates significant health because the tree is able to get the nutrients it wants from that route. When you get a high density, it's often because you've got anastomotic roots that are trying to get nutrients from an area that's not providing as much nutrients from that area as required. So saying that if you damage the low density area, that will be less damaging, you could argue to be more damaging.
Thank you. Are there any kind of urgent comments anyone wants to make before I've still got a couple of questions left on to look at trees, so we're not moving on from the topic, but I think given it's after 12 o'clock, we're probably due a comfort break. How much time do we need? Is 15 minutes likely to be enough, or do we think we need a little bit more? Okay, so 15 minutes, so it's just nearly short of 12 now. So if we come back at 12. Thank you. we're ready to get started. So I appreciate it was a bit of a short break, but thank you for coming back. Right, so just a couple more questions on trees from me. Just if we can just put ourselves in a situation for the moment where I find that a no dig or reduced dig solution would be feasible here. How certain could I be that the health and longevity of tree T2 would be safeguarded? And I'll come to Mr. Bush first, please.
Generally speaking, in situations where site conditions will allow for a no-dig solution, it is a industry recognised method of constructing surfaces within the RPA of a tree, due to the sort of obviously the need to not dig down into the underlying soil structure to significant depths, and due to the load spreading probability, the load spreading nature of the semi-confinement system, whereby it spreads the weight across the entire area rather than it being concentrated within a specific area, and thus reduces the likelihood of compaction damage from obviously vehicles, people, etc., going over such surfaces. So if it was feasible, then it is an industry recognised method of construction, as I said. And in instances where it does, where sites do allow for it, it can not necessarily impede the affected tree to significant extents.
Mr. Pratt?
Yeah, I'd just like to add to Mrs. Bush's comments there. An important point to make is that the extent of incursion is 17.5% of the root protection area, and that falls below the acceptable thresholds within the British standard. So it's within a degree of tolerability for the tree, and that's commonly known within the published guidance of BS 5837. So we are following the appropriate steps in terms of the design and the extent of surfacing within within the RPA, which suggests that this will not have a detrimental impact on the tree. I'd also like to add that there are opportunities to improve the soil environment of this tree before we lay the surface. We know that it's disturbed. We know it's a bit compacted from the pro. There are ways in which we can decompact the ground, that we can add mulch, we can add composts. There are some innovative ways in which we can improve that soil environment, then lay the surface on top, which I've considered in my evidence.
Thank you. And then in the alternate, if I were to find that a no-dig or reduced dig solution would not be feasible, what would the likely effects be on tree T2? And again, I'll come to Mr. Bush first.
In my experience, it would be highly detrimental to the tree, given the area of rooting lost and the excavations required to do that, which would inherently result in root severance, and it would remove a large percentage of the tree's key rooting area, which is the minimum area required to sustain a tree underneath the BS. And although it's acknowledged that the incursion is 17%, the threshold is 20, so it's only a few percentage points lower than the actual threshold. And the default of the standard is that development within the RPA should be a last resort unless there's overriding justification. Technical solutions, I acknowledge the overriding justification in this instance likely refers to the site needs to be accessed. This is the point we've chosen for the access. But the council's point is that the technical solutions provided aren't sufficient to safeguard the tree, regardless of the incursion falling below the 20% threshold.
And Mr. Pratt.
Thank you. In my view, a conventional access that isn't constructed above the existing soil levels would result in impacts towards roots. There are means in which that specification could be laid, but that would involve a relatively uncertain approach, I think. It would involve kind of air spading out the full extent of the root protection area, filling those voids around the roots with the type MOT type, and that's probably a 600 mm depth. Might have to, is it around 600 mm in total? 600 mm for a conventional dig. So if we can imagine having to excavate 600 mm down, we can see from the radar report that would affect roots. So my view is that it needs to be reduced dig, and that is feasible.
And just so I could be absolutely clear, if it wasn't feasible, what would the likely effect on the health of the tree be?
We would see. I would have concerns around safety as would be my primary concern. So if we're looking at damaging roots, whether it could affect the stability of the tree. So I wouldn't be comfortable with the retention of that tree with using a traditional access, mainly due to safety concerns. If it were in a location where there were limited safety concerns, we could look at the options of implementing the access, accepting the root severance and seeing how it gets on. But because of its location next to an access, next to an existing property, I wouldn't be comfortable showing that tree is retained alongside a conventional access.
Okay, so the tree would be lost?
Yes.
Yeah. So just coming back to the sort of details, that you mentioned some details there in terms of improving the soils as well as the potential for a no-dig or reduced dig solution. I just wanted to ask, I mean, obviously I've seen the suggested list of conditions in the Statement of Common Ground. As far as I can tell, the details of that is not before me at this stage. Are the conditions that are before me sufficient to know how that construction process would actually be carried out?
There was one part that we were going to seek an amendment to, the requiring a cross-section and a topographical survey, partly due to the tree's protected status, whereby every part of the tree is protected, including the roots. And while planning permission technically can override that consent, if the permission is given on the grounds of a no-dig solution at a certain depth, and then the works begin and it is ascertained that it's not achievable to do it at them depths, the planning permission wouldn't technically cover any excavations below that due to the protected status of the tree. So there could potentially be complications there. So I think knowing the depth of the excavations and having that sort of set in stone is a key consideration due to the tree's protected status and the potential legal implications of that should excavations exceed what has been specified.
So is this something that's been discussed between the two parties, or is this...
Not necessarily, but I mean, every party is aware of the tree's protected status and every part of it being protected. It was just a little bit that when conditions were going to come up, that we were going to suggest that a topographical survey and a cross-section of the road would be provided as part of any AMS that's conditioned.
Okay, fine, I understand that now. Would you like to say anything on that at this point?
So that sounds logical. I think that further detail is typically provided as part of conditions, and there is a condition in there for an arboricultural method statement. So the additional detail would form part of that. That AMS would be a very robust kind of programme of work around the access. It would need to deal with the access in detail and how it's going to protect that tree in detail. But that work would fall within that AMS that is to be conditioned.
Okay, I think maybe we'll revisit that in the condition session this afternoon. I don't have any more questions on the sort of tree T2 issue. Is there anything that anyone else, I mean, we will look at landscape more widely, but is there anything that anyone would like to say in regard to the tree?
Just one point, we sort of went for the break just before I was able to come back to this, and it's on the feasibility of the no-dig solution. So, and whether, you know, there's what information there is before you on that. So just to confirm that the diagram that you were looking at, which is at the end of Mr. Pratt's statement, does show the change, you know, the change in levels, and that shows a solution at 1 in 10. Mr. Hanks's view, I think, is that we can do it in 1 in 12, which is a shallower gradient. And just to clarify, we need a Section 278 agreement anyway, so it's not the case that we've now come up with the idea that we can introduce a Section 278 purely in order to make this no-dig solution feasible. You know, we need one anyhow, and it's Mr. Hanks's point is that as part of the 278 works, it will be possible to incorporate a feasible no-dig solution, basically.
I think just my question on that is, bearing in mind this is the first time, obviously the council hasn't had the opportunity to consider that solution in any depth. How would it be secured if it relied on land outside of the? I appreciate it would be done under a 278 agreement, but how would it be secured as part of the planning permission, and would there be the relevant certainty to make sure that it could be delivered?
I mean, so the council have seen the diagram at the bottom of Mr. Pratt's not proof, but document. I mean, so that's not new. And my understanding, it may be that others on the team are better able to speak to this, but you wouldn't ordinarily get to the point of discussion of discussing, obviously, particular kind of construction solutions for a Section 278 until you actually appoint your contractors, and then those sort of detailed design drawings would follow. So it's not that there's information missing that we ordinarily would or should have provided at this stage. The technical drawings for a Section 278 would follow after, you know, planning permission's been granted and in the course of those discussions. I can have a think over lunch about whether anything more is necessary in terms of the conditions, or I suppose by way of the Section 106 to kind of give you sufficient confidence that we won't be able to bring the scheme forward without a no-dig solution. But that, I mean, it has to be the case that there is a form of wording that can be incorporated somewhere to make sure that that can all be, you know, secured. It may be that it's a Grampian condition, actually. I'll give some thought to that over the lunch break, but that seems to me to be something that we certainly can achieve. I just need to think about the mechanics of it.
Yeah, I mean, I'm more than happy for you to discuss that over the break, and we can pick it up in the condition session later. I think obviously, you know, from what I've heard, a no-dig or reduced dig solution would rely on land outside of the application site, and therefore clearly, I'd need to understand what level of certainty there was that could be delivered if you were, for example, looking at a Grampian condition. But I'll leave that with you to consider, and then we can pick it up again later.
Sorry, just one more point with regard to the proposed works on the Backs Close side of the site. As sort of highlighted earlier, it would fall within the root protection areas defined on the plans. The additional engineering works required to build up the layers would suggest that it pushes it over the 20% threshold as advised under the BS. Due to the nature of the works and the scope of them.
yeah, so I mean, I guess in terms of the question and response to that is has the detail of this solution been included within the arboricultural impact assessment?
The detail of the reduced dig option. The impact assessment that was submitted noted that a reduced dig would be required for the trees. That was as part of the submission of the application. And then in my evidence, the figure at the end, the cross section, is while not a fully detailed up engineering drawing, it demonstrates feasibility, that it can work, and that shows that there will be some work within the surfacing of Backs Close, the turning head, and just to respond to Mrs. Bush's comment on that, the radar findings are very, very clear in that routing almost entirely drops off when we get to the curb. I dispute that there would be any routes or that works within the turning head of Backs Close would be of any impact towards that tree.
And just so I can be clear, the cross section that I've got, is that specific to the appeal site or is that a general drawing?
It's specific to the appeal site.
Anything else on Treaty 2?
We've got nothing further to add, Mum.
Thank you. So I just want to move on now to look at some sort of wider character effects. And just starting off more local, and then we'll maybe zoom out a bit. I've read and heard lots of concern about the effect on the character of Backs Close and Newtown Road, principally, as I understand it, from the increased vehicle movements that would be associated with the development. Is that something that's been kind of assessed within the appeal documents? Has there been an assessment of that particular aspect?
You're referring in relation to the traffic generation and the impacts on the character specifically, or traffic movement in terms of traffic data?
I mean, from what I've read and heard, there is quite deep concern locally about the kind of noise and disturbance and the comings and goings that would arise from increased vehicle movements travelling along Backs Close and Newtown Road. That's aside from the kind of highway safety issues that have been raised. So I'm just sort of wondering, has there been any kind of consideration to the effect on the character of those streets?
I think the evidence that's before you is concentrated more on the landscape effects in terms of the site itself and the natural landscape features of that. But I think in terms of the character of the close itself, as you'll have seen when you've been on site, there's where the turning head goes, there's views towards the site, which are obviously truncated at the moment by fencing, but those views into the site would be retained through. With the central access road going through the site, would allow visual permeability through the site from that point at the end of Backs Close, so that there'd still be a retained openness and line of sight going into that in terms of the actual character of the street scene. But in relation to the actual existing Backs Close itself and the vehicle movements, obviously there would be traffic movements, pedestrian movements, etc. related with that, which would increase movement onto Backs Close and the experience of that itself. But that's not something that's been considered in considerable detail. But those would be, for the 30 dwellings, would be a continuation of that residential character and use of the road. So I think in terms of how the character of the existing would blend well with what's being proposed in the same layout and the design of the houses is reflecting the existing character. So it'd be very much be a residential use, which would tally in with that. I think given that the relatively small number of houses, you know, that the impacts on Backs Close character-wise would be, wouldn't be significant.
Thank you. Is there anything the council would like to say on that? Ms. Fisher?
I just want to say it would entirely change the nature of Backs Close, having a development there. There is hardly any vehicle movements at the moment. The idea of HGVs reversing back down the road, endless traffic going to and from, it will totally change what is an incredibly peaceful site at the moment. I think it would be unimaginable, the difference.
And when you talk about large vehicles, do you mean during the construction process?
Not just that, but things like the refuse collection and so on. That's going to be quite a big issue. Any deliveries that would come to the new dwellings as well. The constant delivery trucks from Amazon and other delivery lorries, all of that would all have to go past there. It would be entirely different. If you just stand there, you'll just see it's completely peaceful. You can hear the birds sing. Obviously, you can hear Amberley Road in the distance, but you know it's a very peaceful site. Residents have monitored traffic through their Ring doorbell, and it's like, you know, often 2 or 3 a day. This would be constant. So I'd say there's a huge change to the character.
Well, certainly the residents have not been considered by the development. But may I say that every so often the road is shut into Storrington. There's an accident or whatever. And Newtown Road is then used as the rat run by the police to shut the road. And the carnage that causes is enormous. Lorries going over the green pathways, stuck in the mud on the grass that you'll see when you have a site visit. And I think probably 2 or 3 weeks ago there was a minor accident at the top of Newtown Road, purely because 2 cars were going hammer and tongs from different directions, wing mirrors came off. The road, and as I've said earlier, school bus car, it's not designed for a run-through, a shut-through. And you're going to be putting in, 30 houses, let's say, on average, 3 or 4 car movements a day, 120 vehicles during daylight hours. I'm not talking about midnight. Added to the existing traffic, it's going to cause problems. But, you know, if I'm sitting here in 2 or 3 years' time, when the development is done, I can almost hear the words, "I told you so."
Thank you. So just moving to sort of wider character now. Can I just ask, I'm not sure who would take this one, will it be Mr. Hughes probably? Can you just sort of describe how the location and just in brief, how the location and design of the proposal is accounted for its proximity to South Downs National Park and the Dark Sky Reserve?
Yes, Madam. In relation to, if we want to start with the lighting, I think that would probably be the best place to start with that. As you're aware, the whole of the South Downs National Park falls within that classification. The site, as you know, is aside from that. There's an analysis undertaken within the LVIA in relation to this, which is at, just find the reference for you. It's on page 11. We'll talk about dark skies, starting paragraph 2.65. And the background to that's largely to do with the current sources of lighting in and around the site. Because although the Southlands National Park falls within that dark skies classification, it doesn't all have the core of that. So we're adjacent to zone E1A, but really because of the context of the site, which is adjacent to street lighting on Backs Close, Newtown Road and Amberley Road, and with the background lighting associated with that, which again is you can see in some of the wider context in the nighttime viewpoints from the wider views from the Scarp. The site sits within that settlement edge. So the LVA is rightly, in my opinion, suggesting that it's actually zone 3, which is a suburban medium distinct brightness context to the site, which are summarised in the Institute of Lighting Engineers guidance as being well inhabited rural and urban settlements, small town centres and suburban locations. So in that context, the site doesn't share the dark skies in and of itself. And furthermore, there's lighting relating to car traffic movements, adjacent houses, and all of the existing lighting in the area. The proposals have been quite carefully designed with lighting. I think the emphasis in the application material is on ecological mitigation for bats. But what that does tell us is that we're looking at lux levels of about 0.5 at the greatest at some of the site boundaries, using bollard lighting without any overhead street lights. And that's comparable to a bright moonlit evening. And there's some information at Appendix 7 of the ecological appraisal, which was prepared, that shows lux light levels and some illustrative drawings, which are quite helpful, which show the limited pooling of light across the site. And that's in contrast to Backs Close, which has upstanding street lights. So it's very much a low-key design in terms of the lighting and the dark skies, both locally and within those wider views.
And then if I can just invite whoever from the council now, just to kind of explain whether you think what's just been described would be sufficient to overcome any concerns in relation to the wider landscape's character and the setting of the national park.
I think quite a bit of what was just discussed about lighting, that is agreed in the statement of common ground. So that is not a concern. We do believe that the main reason for refusal is the impact on tree T2 and the landscape impact of the loss of that tree, but also the wider impact of the development within that location adjacent to the national park. So there's two different elements as you set out in your agenda, but the points that you raised, I think, we agree, and they're all agreed in the statement of common ground, that they're not an issue.
Okay, so I mean, in terms of your concerns about the setting of the national park, can you just kind of clarify what those are?
Yeah, so it's to do with the introduction of housing to the site with the access, the parking, the street lighting, leading to the loss of the pasture, a loss of openness, and greater urbanising effects above those that are currently within the site.
And I've already heard that I should observe the site from Kickhurst Hill and Springhead Hill. I think those are the right names, aren't they? Yes. Are there any other sort of viewpoints in terms of the wider landscape and the views from the national park that anyone would suggest that I visit?
I'll just point out on that one, if with the zone of theoretical visibility in the LVA was able to scope out those views, which have been agreed with, obviously, with the council and place services, and it just demonstrates the limited impacts visually or visibility of the site and the proposals beyond those sort of areas that are considered. So obviously, I don't think there's any wider ones that I'd be aware of.
Thank you. And then, as has already been mentioned, I think by someone, I have a statutory duty to seek to further the purposes of the National Park in making my decision. Is there anything that anyone here would like to say in helping me to discharge that duty?
Yes, Madam, I'd say, as is quite clearly set out in the officers' committee report in relation to the MPPF and the requirements to for the development to be sensitively located and designed to avoid or minimise adverse impacts. That's a duty that the council are happy has been met, that the proposals have been designed to take into account those sensitivities through various measures, which we've set out in both the LVA and the hearing statement, which is to do with relating primarily to vegetation, containment of the site, and the form of development and how that's contained within the site. So officers have the view that the existence of a slight adverse effect does not amount to conflict with paragraph 189. That's obviously something that I would agree with, that the proposers have responded positively to that.
Could I just check something via you, Madam, actually, please? So the passages that Mr. Hughes was just referring to as 661 to 6.63 in the officer report, and so the officer, as Mr. Hughes said, concluded that the statutory duty had been met. And I can see from the council's appeal statement of case that they're not saying that the impact on the setting of the national park would be more than slight, but I'm not sure that I know the answer to whether they're now saying that there is a breach of the duty or whether they stand by what the officer said on that point. So I'd just like some clarity via you, if we could have some clarity on that, so then I can consider it in the planning balance, please. Thank you.
Would you like to respond to that point, please?
I think that we would stick by what was agreed in the Statement of Common Ground and what was written in the committee report. Obviously, the planning balance is a matter of judgment, but I wouldn't say that we've changed. I can't remember what wording you used. We're not saying that the applicants haven't fulfilled their duty to protect the South Downs. Is that what the query was? Sorry, I can't remember the wording of what you're asking.
I think, as I understand the question, and it's one that I would ask too, is in the officer report, it was stated that the statutory duty in respect to the national park was effectively discharged. Okay. Obviously, the committee members took a different view in terms of the effects on the national park. So the question is the council, what's the council's current position in respect of the statutory duty? If I were to allow the appeal, would my statutory duty have been discharged? Does that summarise your question?
Yeah, my basic point was, as I read the council statement of case, and as you just confirmed, the sort of major point the council's concerned about on landscape is the tree, and I appreciate they're not saying what we're not saying. We're not saying there's no harm either in landscape terms. We've set out the level of impact on the site, and you can obviously see the site from the national park. But so I'm not trying to say that their only case is the tree. I appreciate they are also taking a point on the other landscape impacts, but their case on the national park is that the impact on the setting is slight. So my query was just, if they're saying that the impact on the national park is only slight, do they still agree that the statutory duty was fulfilled, or are they now saying it hasn't been?
I think the answer is that we still believe that the landscape impact on the South Downs National Park is, as assessed before, as slight, and that the duty has been met. And it comes down to, obviously, the planning balance of the harm.
Yeah, I understand that's your point. Thank you. And then I guess again, coming back to the planning balance then, rather than statutory duties, in the event that I were to find myself leaning more towards the council's evidence in respect of the effect on the setting of the national park, and if I were to find harm there, would that amount to a strong reason to refuse the development under the provisions of paragraph 11D I of the National Planning Policy Framework?
Well, our argument is that by refusing the application, we have determined the landscape harm from the loss of T2, as outlined within our documents, would significantly and demonstrably outweigh the benefits of the scheme when applying the tilted balance at 11D.
Okay, thank you. Yeah.
So our position on that is that given the confirmation we've had that the council's case on the specific impact on the national park through the impact on the setting, the council's evidence is still that that impact is slight. So our submission is that even if you agree with their evidence, that's still just a finding of slight impact, and so it wouldn't amount to a strong reason for refusal under footnote 7.
Okay, thank you. I understand your positions on that. Yes, Ms Fisher.
So I just wanted to clarify that it was my submission that mentioned the legal duty under the Levelling Up and Regeneration Act, which requires us to seek to further the park's purposes, including wildlife conservation. I think what we've heard from both of very learned, clever people who have studied these things for many years at university and work in the field, whereas that's not my role, but I can hear that we're hearing that there is harm. It might be slight, but in my definition of harm, whether it be slight or significant, is not the same as seeking further to seek the park's purposes. This does not seek further the park's purposes. It does cause harm, and I think that's important.
Sorry, I do need to respond on that. The reason that I haven't submitted anything that refers to the case law on the statutory duty is because it has never been, and it still isn't, a point that's in dispute between the appellant and the council. It's not correct to suggest that the statutory duty means that as soon as there is some harm, even if it's slight, then the duty can't be fulfilled. And there is recent case law that has essentially reasoned to that effect.
And just moving on to a slightly different issue, I'd like to hear a little bit more about the pumping station. I can see that suggested, I think it's condition 4, would seek further information to come forward about the pumping station. What information do I have about the pumping station in terms of its siting, whether that's indicative or fixed on the drawings, and also its sort of scale, height, dimensions, hard surfacing, fencing, that sort of stuff?
Our position on this would be that the layout of the pumping station is shown on the proposed layout plans. So the layout would be fixed, but the other details, as referenced in condition 4, would come forward as part of that condition submission at a later stage.
So just in terms of the sort of effects on local character, how certain can I be that it would be an appropriate size and scale for the site?
I think there's a condition proposed that deals with this, which and this is a pre-commencement one. So, yeah, it acknowledges that the pumping station is being shown indicatively on the approved layout plans, and it requires full details of the design, scale and appearance, and so on and so forth, to be approved by the local planning authority prior to commencement and then implemented and retained. So it is something that the parties are, as I understand, agreed it could appropriately be governed and regulated through conditions.
My pumping, I'm sorry, I can't always hear over here, but we're referring to pumping station. Is this sewage?
Can I ask either someone from the appellant or the council just to explain what the pumping station would do, what it's for?
Because if so, if I may say, when Bats Close was built, houses at the bottom of Warren Croft had sewage coming up in their downstairs toilets. And the point I'm making is that we're now going to be adding another 30 dwellings, 90, 100 people. And I think certainly the local population would want absolute categorical assurance that the sewage works in Horsham Lane, with additional houses that are being built off Horsham Lane, can cope with the additional amount of sewage and wastewater. Now, we haven't had a problem in the, 15, 16 years since Bats Close was built. But initially there was a problem. And this is not something that you can, that the residents can test. All they can hope for is that when finally, if this development goes ahead, we are not going to be backed up with a major problem. And I've not heard anything from the Southern Water, who are under tremendous pressure, firstly to provide water, but secondly to deal with wastewater, that the Horsham Lane Sewage Works has adequate capability or capacity, if I may say. So I don't know how A2 Dominion give us reassurance, but by Jove, we need it.
I've heard your concern there, so that's something I'll consider. Thank you.
Can I just
Who wants to go first?
I have my hand up as well at the same time. Is it okay to talk now?
Is it on the same point?
Yes, it's on the
Okay,
character
let's hear
of
your
pumping
comments
sta-
first
to
then,
answer
and then-
your question about the character of the pumping station. So just to remind everybody that the Bats Close Group submission explicitly says the introduction of housing to the site, together with associated access, parking, street lighting, fencing, a pumping station and other forms of supporting infrastructure would significantly alter its existing character. In Councillor Beard's submission, she describes the current site as open pasture with mature perimeter vegetation. It reads ecologically as countryside, a green buffer supporting wildlife movement between Storrington and the National Park. And notes that development would introduce a pumping station with associated infrastructure as part of the urbanisation of what is currently a rural edge. And then in terms of planning policy relevant, there's HTPF policies 25 and 33, which expressly ask for the landscape character to be supported. And then just to reiterate, the pumping station is functional infrastructure, which is likely to be visually prominent in open countryside, noisy and incompatible with the rural character of landscape character area EA, which is Parham and Storrington, wooded farmlands and heaths. So I hope that's helpful.
I was just going to come back to your earlier point in terms of the purpose of the pumping station. So in the flood risk assessment, submitted flood risk assessment at 8.2, there's an outline there of the purpose of it and what it seeks to achieve and why it's required on the site. I've got the relevant paragraph to hand if you'd like me to read that out.
I think it was more just answering Mr. Chisholm's question about the pumping station. I just wondered if you could kind of briefly explain for his benefit what the pumping station would be for.
So it's required to drain foul water from the development into the nearest sewer.
Does that answer your question? He said it's to move wastewater into the sewage from the site into the sewage system. Does that pretty much summarise what you said?
Yes.
Yes.
Not necessarily the process. My point is that process, or I'm going to have problems.
Yeah, I understand your point. Thank you.
Sorry, just on that point, the various statutory consultees have commented on the planning application, so the Environment Agency and I believe Southern Water as well. As far as I'm aware, they've raised no concerns over sewage capacity.
Yeah, the point I was going to make briefly on that is going back to the character point. The pumping station shown on the landscape proposals plans is being set in an area where there's potential for tree planting and hedgerows to set it back. So it's not in a prominent position and it sort of sits within that framework. So that might be helpful for you when you're looking at how that might appear in character terms. I think just picking up on Councillor Fisher's point as well, strayed a little bit into the actual wider scheme as well. And it's obviously been our case that whilst there are localised impacts, the scheme has been carefully designed to retain those key features, including the existing tree framework, and the watercourse, etc., and to take account of the built form and character of Storrington in that location.
Thank you. And just again, so I can be clear, so the suggested condition 4 refers to the location of the pumping station as being indicative, but actually you're saying that that's fixed on the plan.
It's shown as an indicative location on the plan, but just illustrates how that could be treated to sit within the street scene. So pumping stations can be obviously can be integrated into the landscape planting to soften them and to put them into areas which aren't prominent within the street scene.
So I believe that concludes my questions on the main issue. Does anyone have anything else they'd like to say in respect of trees, landscape character, setting of the national park?
Just one point from me, Madam. I know I talked very briefly about the dark skies element of it before we moved on. I think it's a very helpful analysis within the OVA at Appendix 6, an assessment made against the special qualities, and it's basically the special qualities have been respected of the actual national park itself, because obviously we're not within it, so they don't necessarily all apply to the site, but actually the natural beauty criteria and the assessment contained there demonstrates that the proposals don't impact the special qualities of the national park. That includes the visual setting, but also the opportunities for open air recreation in the national park is something that's not impacted, but actually, the access to the national park is provided from the site using the existing rights of way network.
Anything else on the main issue?
Madam, can I just ask at what point you'd like to hear submissions, if any, on policy, but also I noted the council when we began, the reason I'm asking is because when you asked for clarity on which policies the council was referring to, I think policy 30 was added to the ones in the statement of case, but it wasn't said whether the council's saying there's a conflict or not. So I'd just like to understand their position on that, and then at some point address you on what we have to say in response.
Do you mean specifically on the 3 policies that have been referred to in relation to this main issue, or more generally?
It's really, I mean, I think I previously understood what they were saying on the other 2 policies. It's just this new reference to policy 30 that I don't have clarity on whether they're actually saying there's a conflict, or they're just saying it's relevant, or what their actual case is on it. Thank you.
So policy 30 is protected landscapes. So when I was reading through the agenda, it made sense that the second point, character and appearance of the area, including respective setting in the South Downs National Park, would relate to policy 30, which is the local policy on protected landscapes. It refers to the South Downs National Park being conserved and enhanced. So to me that links with that reason.
And so I understand you're saying it's a relevant policy. Do you identify conflict with that policy or not?
No, we won't introduce that policy.
So do I take that to mean you don't find conflict with that policy?
We haven't referred to it previously, so we won't refer to it again.
Do you have anything you'd like to say on that?
No, madam. Unless the council's going to positively say to you they think they're now saying there's a conflict, which they've just told us they're not, then I don't. Our case is that there's not a conflict, so it's fine. Thank you.
Did you want to say anything in relation to the other 2 policies?
Sorry, I'm just getting them up. I mean, I don't think there's anything sort of very specific on policy 25. We don't consider that the scheme would be inappropriate development, and overall the impacts. Sorry, let me just find the table. Yeah, so this for your reference, madam, we've provided a summary of policy compliance table in the appendices to our statement of case. And so, yeah, our position is still that because of the limited and localised landscape effects, there's no material non-compliance with policy 25. And I'm afraid I can't recall. Oh, it's HD. It's policy 33, I think, is the other policy the council refers to.
That's what the council said earlier.
Yeah. Yeah, we, for the reasons we've set out in our written submissions, we don't agree there's a conflict with that policy.
Do you have anything you'd like to say in response to that?
It's all set out in the appeal statement. We think there is a conflict. Policy 25 seeks to protect and conserve landscape character and specific key features and characteristics of the landscape character area, and so we believe that there is a conflict there.
Thank you. Is there anything else before we move on to the next item on the agenda? That is spatial strategy. I mean, to be honest, I'm fairly clear. I understand everyone's position from the written evidence, but I did just want to double check. In the statement of common ground, it says that the housing land supply position is 1.7 years. Has there been any change to that position?
No, that's the same.
And I also see from the statement of common ground, if I've understood it correctly, that it's agreed that paragraph 11D of the framework is engaged, and that therefore that policies 2, 3, 4 and 26 of the development framework and policy 1 of the neighbourhood plan are out of date. Is that correct? But I just wanted to be clear.
Sorry, I mean, our position on that is that all of the policies that the council are alleging are breached are out of date because they are, important to the determination of the appeal, and the council hasn't got a 5-year housing land supply. So just to be clear, because we've now got the suggestion of policy 30 as well.
Thanks for that clarification. I did also just want to be clear, because I don't think this is explicitly stated anywhere, but is it also agreed with terms of the policies that I mentioned earlier? So that's 2, 3, 4 and 26 of the Horsham Development Framework and Policy 1 of the Neighbourhood Plan. Is it agreed that there's conflict with those policies? I think I understand the council's position is stated, but I'm not sure the appellant's position is actually explicitly stated in terms of those policies.
Just finding you the reference, madam. Let me check which document I'm in first. Yeah. So the reference is the policy compliance table, which is Appendix B to the hearing statement.
I've got that, yeah. Thank you.
Does that, mine's being a bit slow to load, but essentially that sets out our position. So you'll see, for example, policy 3, we agree there's conflict, but we say it's out of date because of the housing land supply position. So hopefully that should cover, I think, the policies you're interested in.
That's helpful. I had seen that, but clearly had forgotten that I had it when I'd written the question. Thank you. And it will be for me to make a determination as to the weight that should be attached to the conflict with any policies where there is conflict. Is there anything that anyone would particularly like to say on the weight? I'm specifically talking about the spatial strategy policies here. Is there anything that anyone would like to say in terms of weighting that should be ascribed to those policies?
I mean, our position is that the weight should be very, very significantly reduced, given that it's well established in the case law that one of the factors the decision maker should consider when, I agree entirely, weight's a matter for you ultimately, ma'am, but in considering what weight to give. One of the factors to be considered is the extent of the shortfall in the housing land supply. So, for example, if the council had a 4.9-year housing supply, the tilted balance would still be engaged. But there, in my submission, there would be a less strong case to say for a significant reduction in weight. Whereas here, the council's missing, on my maths, 3.2 years of the 5-year supply. It's a significant, it's a very significant shortfall. So, our position is that sort of increases the weight that needs to be reduced when you're applying the policies that we accept that we don't comply with.
Is there anything the council would like to say on that? That's fine. Yes, Miss Fisher.
Thank you. Just since we're talking about the tilted balance, I just wanted to see if it would be possible just to bring up the protected species and habitat section to talk about alongside this, because that does impact the tilted balance, or should I wait till we get to that section?
I think I'd like to cover that when we've got it on the agenda, and there is a section, there is also an agenda item on the planning balance.
Okay.
So my questions just then were specifically around the policies related to the spatial strategy. That's okay, otherwise we'll jump all over the place.
Yeah, no, that makes sense. Thank you.
Is there anything anyone else would like to say? Yes, Mr. Watson, thank you.
Thank you, Madam. It was just to draw your attention to the Council's Shaping Development Planning Advice Note, which I recognise isn't part of the statutory decision-making framework, but in it there's a strong acknowledgement of the Council's very serious housing land supply shortfall, and an acknowledgement from the Council that it would receive applications in locations not supported by the development plan or neighbour plans, and explains that such proposals should be assessed positively where they represent sustainable development and meet identified needs, as is the case with the appeal site. Thank you.
Anything else on that agenda item?
Sorry, I just wanted to say that in that shaping development in the district document, if we're going to go into the details, there is bullet pointed criteria for applications that we will be looking for. So one of them includes the development.
Bear with me a moment while I just get the document.
It's paragraph 5.12.
Yeah, I've got that now.
Yeah, so the last bullet point, I just wanted to really just draw your attention to where it talks about the development being contained within an existing defensible boundary and the landscape character features maintained and enhanced.
Anything else?
I think just on that reference to the bullet point, and the landscape character feature that's complained about here is a single tree. So we certainly wouldn't accept the suggestion that the fact that, I mean, our primary case, of course, is that the tree will be fine because we have a feasible solution. But even in the alternative analysis where that tree is removed, we wouldn't agree that the loss of a single tree would mean that we don't benefit from the support in that paragraph.
Just one point on it being a single tree. I mean, the tree is subject to statutory protection under the TPO, protected because of its landscape and amenity importance and its contribution to its setting. So although it may be a single tree, it is a tree of importance that contributes to the area where it is located.
Okay, I think I'm probably ready to move on to the next agenda item, which is highway issues, traffic and accessibility. So, I mean, we touched a bit on traffic when we were looking at character earlier, but but specifically, you know, there's lots been said in the representations that I've received about the effect on highway safety. Someone from probably yourself, sir, can you kind of just set out what you believe the effects of this would be on highway safety?
Thank you, Mum. So, first of all, I suppose we should start with highway safety records, collision data from the DFT. Now, safety concerns have been raised over the Amberley Road, Newtown Road junction. DFT data shows there's been one recorded incident there in the last 10 years that's caused an injury. So that's a very low incident rate, indicating it works very safely. Visibility displays at the junction are policy compliant, and in fact the highway works that are proposed to be secured to put a new footway around the south-west corner of that junction will improve visibility displays as well, because currently, as you'll probably see on site, visibility can be obstructed by undergrowth and vegetation when it grows there. So there'll be an improvement to that junction in terms of its visibility, which is very important. And a gateway feature is proposed where the speed limit changes, which will help to reduce speeds and highlight the change from one speed limit to another. Similarly, Newtown Road has been raised as a concern in terms of its width and some lacking footways in some places. The Highway Authority's consultation response in October 2024 specifically mentioned Newtown Road, and that they're aware the vehicle flows are very low on Newtown Road, and that therefore it's suitable to act as a shared surface. And they were content that there's not a safety issue there. Going back to highway safety records and collision data, there's no indication of any, there's been no incidents there in the last 5 years on Newtown Road. And it operates safely. In terms of the volume of traffic that the scheme would generate, the busiest peak hour would generate 17 vehicle movements. They go through Backs Close and then split north and south on Newtown Road. So assuming a roughly 50-50 split, you'd have 10 vehicles going in one direction and 10 in the other in the busiest peak hour. That's an absolutely tiny number of vehicles and impact, especially considering best practice guidance suggests that highway capacity assessment should only be undertaken or is only necessary with more than 30 vehicles in a peak hour being added to any given junction. And the development will not generate more than 30 vehicles in a peak hour, full stop. So in summary, I think highway safety records show that the local highway network works well and safely. There are benefits in terms of improvements to highway safety from the highway works to the Newtown Road, Amberley Road junction, and the new gateway entrance feature, if you like. So I don't, and I should have added it's common ground between the Highway Authority, the Planning Authority, and ourselves. There are no issues with highway safety or traffic impact as a result of the appeal scheme.
I just wanted to double check the issue about the visibility at the Newtown Road, Amberley Road junction. So I did drive that yesterday, and it is quite obscured, the visibility there. It was when I was there yesterday. You mentioned that the proposed footpath would help that situation. Can you just explain why that would be the case?
So if you're exiting from Newtown Road onto Amberley Road at the moment, when you look right, which is toward where the faster traffic comes, then often at the moment vegetation, which is within the highway boundary but not well maintained, as is quite common, can obstruct visibility. But on plan you can provide suitable visibility displays that meet the relevant standards in that direction, but obviously on plan is different from what's maintained. Once a footway is put in that location, which would go along about 30 metres of the edge of the carriageway and then cut into the side, then that means that automatically stops vegetation from growing within that visibility display, because there's then a footway there rather than just a grass verge. So that's the improvement that will be achieved to visibility at a junction where there isn't actually a safety issue at the moment anyway, and other than what's perceived.
And whose responsibility is it, or will it be, to manage that vegetation?
Well, the vegetation will be managed by dint of there being by the fact there'll be a footway there, a 2 metre wide footway, and so unless vegetation is allowed to grow so significantly that it makes a significant sort of cut in across the top of the footway, then it will protect those displays, and it is ultimately Highway Authority's responsibility to maintain the visibility displays, but maintaining those will take a great deal less work when there's a footway there rather than grass.
Thank you. So anyone wants to say? Obviously, I have heard all of the comments that have been made, so I don't want to hear the same points again, but if you have anything additional to say, then please feel free to.
Referring to the gentleman's comment that the grass is cut. Grass is cut by residents who can't see. It's not done by the highway authorities. So to put something in there that says, oh, well, the highway authorities will take responsibility, they don't now. And if you're in a car turning right off Newtown Road into the Amberley Road, you are blind. You have to edge out into the traffic. And that famous expression of statistics and damn lives, one accident in 5 years is preposterous. There have been several. So they're either not being recorded or there's something missing.
Well, if I may add one point, that footway that's proposed and the link to the development there obviously provides the most direct route from the site to the town centre, and thereby reduces the number of pedestrians that need to walk up Newtown Road where there aren't footways. And those highway works include new drop curbs and tactile paving to cross across Newtown Road there near to the junction. And as we say, the visibility displays at the moment, lack of maintenance causes an issue, can do with the displays. In the future, there'll be a lot less maintenance needed if it's tarmac footway rather than grass verge.
Yes, Ms Fisher.
In terms of this footway, the committee were told that there was a 6 foot footway all the way from Newtown Road into Storrington. That's just not the case. It goes down to a very small, residents have measured it. So putting in a new footway to join in with a footway that's not adequate isn't really going to make it a better way for people to get into the village. So I think that's important to note. The other thing is the gentleman mentions a maximum of 30 vehicle movements at the busiest hour. Given that we end up with barely more than 1 or 2 an hour, that's a huge increase in terms of the vehicle load, and it's a serious concern to many people. And I think we'll find many accidents happening if that did happen.
So in terms of the routes that are proposed through the development site, as I understood it, the Highway Authority had sought conditions requiring further details about those roads and footways to be submitted, and then a sort of condition triggering their implementation prior to occupation. I couldn't see a condition along those lines in the Statement of Common Ground. Again, I guess maybe I'll just put a marker here that might be something we need to revisit when we look at the condition session, and whether it would be necessary to have such a condition, or if it was excluded for a reason. And then in terms of the off-site highway works that are proposed, there's drawing SK04. I guess in the council's view to start with, does that provide sufficient detail about what would be secured? It's the drawing of the off-site highway works, which is SK04, which I believe was in the transport document.
It's Appendix B of the transport statement. Yep.
I mean, our statement of common ground, we've agreed that there's no outstanding highways issues. So I believe if that was something that we had that we've had before, that we've already got, then that's been agreed by us.
Okay, thank you. So I don't have any more questions in respect of this issue. I have heard the strength of feeling from the local community about highway safety. I have read all of the representations that have been made on that. I've also heard and read the views from other parties, and I will consider those carefully and take them into account. Is there anything that anyone else would like to say on this issue before we move on? Okay, so that brings us on to the Grade 2 listed building, Cobb Court. Again, I think I have most of the information I need from the written evidence to be able to form my own conclusions in respect of the effects on the listed building. I just have a couple of points of clarification, which was firstly just to understand what extent the setting of Cobb Court and specifically the appeal site contributes to the significance of the heritage assets.
Sorry, are you asking the council that question or the?
Sorry. Yes, please.
Well, we had a
Nearly lunchtime.
We had a no objection comment from our conservation officer. So the council's opinion is that I'm just going to read that out. So it says the accompanying heritage statement describes the surrounding built and buried heritage known at this time. I am in agreement with the conclusion that the setting of the listed building is already impacted by the existing suburban development and that the proposed additional development will have a neutral impact within its setting. I raise no objection on heritage grounds. And then it just says that detailed conditions should be placed in relation to design. So we've agreed in the statement of common ground that there's no outstanding heritage concerns.
Okay, thank you. Is there anything, first of all, that the appellant side would like to say? I appreciate I don't think we've got a heritage person here, but is there anything?
Only that I think the reference for this, Madam, if assuming you have the application documents available to you, would probably be the heritage and let me get the title right, the heritage and archaeology statement, and then the setting of Cobb Court is discussed at 4.2.6 and 4.2.7, which refers to limited glimpses of the stucco front being visible from Newtown Road, and they make some contribution to significance because they allow the polite pretensions of the remodelled facade and the relationship between the house and the former common to be appreciated. But then it goes on to explain that the wider setting, of course, is characterised by late 20th and 21st century suburban housing development. And in a nutshell, I mean, I'll leave you to refer back to that yourself, but I think the point that's being made is that the wider setting of Cobb Court has been impacted by modern development. So, and then goes on to explain that the northeastern corner of the site could be said to form part of the wider setting. So, yeah, I think those are sort of the background explanation for how an ultimate conclusion of neutral impact on significance was arrived at, because the setting itself is already very largely influenced by existing residential development that's modern.
Thank you. Ms Fisher, did you want to say something?
Yeah, I just wanted to point out, and I'm sure you're aware, but just to reiterate really that the 2016 inspector found that the development on the appeal site would cause harm to the setting of Cobb Court. I understand that the conservation officers, HDC's conservation officer, assessed that as not having neutral impact. But given that Bax Close was built in around about 2002, we're talking about an inspector's view that it actually had less than substantial but weighty consideration in the overall planning balance, and that was 14 years after Bax Close was built. So the argument that Bax Close has appeared, so now it's all fine, is not the same. And this 30 housing development is very similar to the one that was refused in 2016. So I do think that's actually very important. And I think glossing over it is something we shouldn't do, because it is important. And it's rural setting that is the important part here, because all of a sudden it's not rural if you put 30 houses the other side of it, between it and its countryside.
I think that's what brings me neatly on to my next question, and I do appreciate...
Sorry, Madam, I do want to give you a specific reference on this point. First of all, I'm not relying on the Bax Close having come onto the scene. My reference was actually to the much earlier surrounding residential development, but the previous inspector's conclusions are addressed in the officer report, and at 6.92 the officer notes, this is contrasting the present application with the previous one, the officer points out that the current scheme that you're looking at, Madam, doesn't seek to introduce housing within the northeastern section of the site, and as such would therefore better preserve glimpsed views of Cobb Court to substantially the same extent as currently available. This is in contrast to the previous appeal proposals, where the housing proposed to the eastern side of the proposed access was a significant factor in the inspector determining that less than substantial harm to the setting of Cobb Court would result. So the basic response to Councillor Fisher is that the layout of this scheme is materially different and doesn't impact the setting of the listed building.
That answers my next question. Thank you. That's fine. I need to come to my own judgment, but I think I understand the positions now. So that brings us on to protected species and habitats, including habitat sites. So just looking at, again, it's really sort of points of clarification really I've got here, because I've obviously seen the written evidence on this from various parties. But the ecological assessment recommends a range of specific mitigation measures for a variety of protected species during the construction phase. And I note that the assessment recommends that a construction environmental management plan would be submitted, and requests various further details such as pre-commencement walkover surveys and precautionary method statements, etc. I think maybe again I'm just leaving a note here for the condition session, because I'd like to consider whether condition 6 adequately secures those specific measures. So it's probably best we pick that up again in the condition session. And then I wanted to hear a little bit more about how the translocation of slow worm would be secured if the appeal were to be allowed. As I understand it, this would be an off-site location that's outside of the red line, and I can see in the draft section 106 there is reference to the reptile mitigation strategy, but yeah, just any further detail please about how that would be secured and how certain I could be that it would be deliverable.
Madam, is that a point we might be able to pick up in the section, sort of in the conditions in section 106 session, just so that I can ask my team to sort of look in the documents and see what the points are that they'd like to make to you on that, please?
I'm happy to do that. There is a condition that refers to the reptile mitigation strategy. I've not got the number here, but that is a condition that I'd quite like to look at the wording of, because I'm not sure that it would achieve what it's intended to do at this stage. So yeah, that might be one to look at the lunch break. And on that note, in terms of the sort of biodiversity mitigation that's proposed and the enhancement works in the long term, I just have a few questions about how these things would be secured and the sort of overlap between statutory biodiversity net gain and ecological mitigation and enhancement works, and whether they're same things or different things. But yeah, if you can just sort of have a look at those and we can discuss them again later. So just looking at the European habitat sites, just to clarify, I think I understand from the written evidence, but would there be the potential for effects on the Duncton to Bognor escarpment special area of conservation? Whoever can find the information first is welcome to answer, and then I'll ask the opposite side.
So the reference, Madam, from our perspective is the ecological assessment in the application documents, and then 4.9, which explains that because that SAC is 8.3 kilometres west of the site, the author of the documents reviewed the information available and concluded that there were no impact pathways that needed to be addressed as a result of proposed development in Horsham, and points out that the HRA done for the local plan, which is a 2023 document, explains that the two impact pathways that may have been relevant potentially were changes in recreational pressure and air quality, and then that HRA for the local plan screens out for the proposed local plan allocations, which include 18,700 new residential dwellings, and therefore the logic, I think, is extended on the basis that if there's no potential impact pathway for that large number of dwellings, then there's no potential impact pathways either from this proposal for 30 dwellings.
Did you want to say something, Ms. Fisher?
Yeah, when I asked before, I was asking if I could say something here about the protected species and habitats and the impact on the tilted balance. So is it okay to talk about that now? So it's not specifically about the...
Can we go through my questions and then I'll come back to you, because it might be that
yeah, that makes perfect
scoop up things that we've said.
Okay, thank you.
I am conscious as well it's 10 to 2. I'm anticipating no longer than 10 minutes, and then we'll have lunch, just to make you aware, in case anyone's tummy's rumbling. Did the council want to say anything in respect of the Duncton to Bigmore, Bognor escarpment, Zach?
No, we don't have any ecology objection received, so we've got no comment on it.
And in terms of the, I think it's called the men's special area of conservation. There's a few different names for it in the evidence. Again, maybe one that we can pick up with the condition session, but the shadow habitats regulations assessment that was submitted refers quite explicitly to construction work ceasing before dusk. But I note that condition 6 indicates there could potentially be construction lighting, including flood lighting. So again, I just wanted to look at that. But again, we can pick that up with the construction, with the condition session. And then with Natural England's withdrawal statement, I think I understand your positions in respect of the Arun Valley habitat sites. I just wanted to be clear, based on that withdrawal statement and the council's change of position, is it necessary for me to carry out an appropriate assessment in respect of the Arun Valley sites?
So we would normally carry out an appropriate assessment, even though no specific mitigation is required, because we are looking to still account for all water used through development. So it's to do with the overall strategic strategy for water usage. We, as officers, we do appropriate assessments still. So I believe that you should do one. We would have done one already, but then it would have changed.
That's fine. I'm just interested in your position on whether I need to do one or not.
We are still, as officers, carrying out appropriate assessments.
Can I ask?
I think probably the most sort of legally robust basis to proceed would be to do one, but I mean, it wouldn't need to be. The ultimate point is you need to ensure that you have satisfied yourself there's no adverse effects on the integrity of the site. So yeah, that's the sort of most robust way to go about that, I would suggest, would be to just go directly to considering that point. And then on the information, our position is that on the information you now have in front of you from Natural England, you have sufficient information to be satisfied that for the reasons that's set out in the documentation, there isn't a prospect of an adverse effect on the integrity of the site.
Thank you. I'll reflect on those comments, and just to make everyone aware here that I have consulted Natural England on the appeal in respect of the effect on the European habitat sites. I haven't yet received a response to that consultation. I don't think at this stage it will be necessary to keep the hearing open pending that response, but clearly if and when it does arrive, if I feel there is a need for the parties to comment on it, then it would be open to me to allow for a written exchange of submissions. That would be my intention at this stage, and it will certainly be forwarded to you if one arrives. That completes my questions on this issue. I know that Ms. Fisher wants to make some comments. Should we do that now?
I won't take too long, thank you. So just on the point of water neutrality and the impact on water, it's really important to note that this site backs onto the Amberley Road. That means the road that goes to Amberley, and we're talking about direct impact on the Amberley Wild Brooks and the water levels there. So would be the closest urbanisation before you get to Amberley and the Wildbrook. So that is a really important thing to understand its location. And then on relation to the men's special area of conservation, it's important to note that the southern boundary vegetation forms a critical corridor for Barbastelle bats, which is a protected species under European law that may be functionally linked to the men's special area of conservation population. And in my view, and many others, the ecological assessment does not adequately address whether an appropriate assessment is required. And it hasn't concluded there would be no effect on the men's SAC integrity. So we know there's Barbastelle bats on there and slow worms, but there's also likely to be common lizards, grass snakes, dormice, nesting birds, hedgehogs and invertebrates. And specifically when you're talking about the mature oak T2, it's really important that that is also included when we're talking about protected species and habitats, because that can support 326 species of beetle, 257 species of lichen, and numerous other invertebrates, fungi, birds and even mammals, which I can't list. So when there are significant effects of something like this development, and those effects can't be ruled out, then of course there's a precautionary principle. So it's important to make sure that that assessment is completed. And that also means that the tilted balance doesn't apply, as in NPPF paragraphs 195 and 11D and I.
Thank you. Is there anything that anyone would like to say in respect of protected species and habitats?
Well, just in response to Councillor Fisher's remarks, the Council's ecological consultant, Ms Broad from Place Services, undertook the habitats regulations appropriate assessment, and the potential for impact on Barbastelle bats was screened in. So she did consider, you know, what the potential impact on the bats was. But her conclusion was that having regard to the avoidance and mitigation measures proposed, the project will avoid an adverse effect on integrity. So I'm not quite sure what the suggestion was, but it's not correct to suggest either that bats were overlooked or that there isn't evidence before you from a qualified ecologist to reach a positive conclusion on the absence of an adverse effect on integrity. And the point about the southern boundary corridor being significant for bats is a point I picked up earlier, and is another reason why, you know, accessing the site from Amberley Road would be a less optimal approach.
And you'll be prepared to, or someone from your team will be prepared to discuss how those mitigation measures would be secured as part of the condition session. Anything else on that agenda item? Excellent. And I think we're probably all hungry now. Just as a bit of an update on timing, my questions in respect of noise and disturbance, which is the next item on the agenda, we've actually covered previously under character. I sort of brought that forward a bit. I will give everyone the opportunity if there's anything else that wants to be said. But then hopefully we can move quite quickly through the remaining bullet points under condition 4 when we come back after lunch. How long do people feel they need for lunch? I'm fairly flexible personally.
Could I, subject obviously to ultimately what you'd prefer, Madam, I think it would be helpful if we could have a full hour, just because I think there's probably half a dozen points on the conditions and the sort of methods of, or the mechanisms for securing mitigation and so on, that I feel as though the more time our side of the room has to just think about those in advance of the session, hopefully the sort of more swiftly we'll be able to respond to your queries on that.
That's fine by me. So if we do an hour for lunch, obviously the longer we have, the less likely it is we'll get to the site today, but we can see how we go. So yes, it's now 2 o'clock. So if we meet back here at 3 o'clock. Thank you. It's just gone 3 o'clock on my clock. Everyone's fed and watered. We had long enough and ready to get back into it. So just before the lunch break, I concluded my questions in respect of protected species and habitats. The next item on the agenda is noise and disturbance, and I'd actually covered off my questions earlier today. Is there anyone that would like to say anything about noise and disturbance? I can see I've got a hand over here. Is anyone? Go ahead then, Ms Fisher.
Sorry, I just wondered if it's possible just to ask 3 points of clarification before we start that have kind of come to mind over the lunch break. Which
This is generally from
this
the
is from what we've
proceedings,
covered
not necessarily
already.
on that agenda
Yeah.
item. Yes, that's fine, yeah.
Okay, brilliant, thank you. So just speaking to a resident who, when we were talking about species and protected habitat and so on and so forth, that glowworms haven't been mentioned. He reported that they found 12 in one night last year. And they've been recorded via iRecord, and there should be Sussex biodiversity records for those. But I'm quite surprised that they haven't been mentioned by anyone. I don't think it's in the report either. So just to highlight that. Then just before we broke for lunch, I made a point about the Barbastale bats and the men's special area of conservation, and that's being the flight line. The appellants were saying that that's why there shouldn't be access on the Amberley Road, but the housing, if you look at it, runs all the way along. So there's going to be a disturbance to that corridor, whether there's an entrance or not. So I'm talking about kind of keeping common sense prevailing here in terms of the impact on everything else, so balancing it up. And then the third point I wanted to make was there was a talk again from the appellants about raising the level of the entrance to Backs Close, going over the routes to make it less impactful on the Oak. But I just can't find any reference to that. So I'm just wondering if there is a reference that I can have a look at, because I did have a good search on the documents and couldn't see it. So I haven't been able to think about it or commented on it, and I don't think other people have either. Thank you.
That's fine. Can I sort of come first of all to whoever it is from the appellant team, just to kind of respond to those points raised?
Glowworms are not protected, so there isn't an omission there. I've never seen a suggestion that development should be refused because of potential impact on glowworms. It's not a concern raised by the ecologists on behalf of the council. I don't have anything to add on the point made around the bats and the southern corridor. I'm content with the answer that we gave before lunch, and the information in relation to the change in site levels I consider that I've already dealt with. As I explained, the relevant drawing is the one at the end of the arboricultural hearing document, and that, you know, indicates in a level of detail that is what would be expected at this stage. What we're proposing, we're not proposing sort of, it's not really building over, it's just addressing the change in levels, which isn't a particularly extensive one, that there is between the road in Backs Close and where the access road in the site will need. So yeah, the short point is I don't think there's anything that we haven't already covered. Thank you.
Is there anything the council would like to say?
I'd just like to see that plan, because I'm struggling to find it. It's probably really obvious, but I just can't see it. Sorry, because I think.
Do you mean the cross section drawing?
The cross section that shows the levels
Yeah,
that would
can
be
we
raised.
find that
I'm
out?
just a little bit concerned that it might impact the levels within the development that we haven't actually considered.
Do you want to take a few moments to look at the drawing? In response to Ms Fisher's point, I will just say that I have heard your comment about the fact that people haven't had the opportunity to comment on that, so I understand that.
Sorry, but we don't agree with that. This document has been submitted for a long period of time, so there's been ample opportunity for it to be considered by the council and by interested third parties.
Sorry, in the appellant's hearing statement, is that where it's at? In? Which was submitted separately to the appeal statement, were they? Sorry, I'm not trying to be
Sorry,
difficult.
to confirm, it's Appendix F of the hearing statement that was submitted.
I think it's an appendix to Appendix F of the hearing statement.
It's the very last page of Appendix F.
Do I sense that you might need a little bit of time to?
Sorry, I just don't know how to find it. I don't know what's in
Is it specifically typed?
Where are we at? Have you managed to find it? Do we? What's happening? Can we move on, or? I mean, if you need a little bit of time, I'd rather if it's a few minutes, I'd rather you make any comments that you want to make today. I mean, clearly I've had a copy of it, so it has been in the evidence. But at the same time, so I understand you haven't seen it. So if understanding that it was in the evidence, but if you need a few moments to look at it, then I'd rather we do that.
Quick 10 minutes.
We have a quick 10-minute adjournment.
Oh, sorry, can I just clarify something though, because I think there was a suggestion from the council earlier that we hadn't provided sufficient information. Are the council saying that they haven't actually looked at this document? So when they were saying that they didn't think they'd got enough information, it was because they hadn't actually seen this document?
I believe there may have been a misunderstanding, yes, that we haven't actually got to the it's
Okay.
referring to, yeah, so that would be correct.
Yeah, I suggest we have a 10-minute adjournment, and then, but what I would like is a clear position from you in respect of that, if that's changed anything that you've said earlier today. So can we say 3:20? And Ms Fisher, I do know that you need to make a point. We'll do that when we come back. Thank you. Is everyone back? It's not quite 20 past, but is it the coming back? Okay, so is everyone okay if we resume? Okay, take two. Do we need a bit of an update on?
Yeah, well, we got to the bottom of the reason why it was not picked up sooner, because the information was indexed directly to the appeal case file rather than our internal system. I hadn't actually picked up on it. I've had an opportunity to review the information, and I don't consider that it changes our position.
Okay, thank you. So we can move on.
We can move on, yeah.
Ms. Fisher.
Just a point of clarification. I understood that we were looking at the plans that were on the table in the application, but this seems to be a change from the plans. Is that, and I don't think, given that it's Appendix F of the hearing statement, that it's been publicly shared widely enough. I think it is really important for Backs Close residents to take a view on this as well. So I just wanted to flag that as being a point of concern.
I understand that point that you've made, so I have heard that, and I will bear that in mind. Thank you.
Oh, sorry, Madam, there's one point just on the question around what happens if a no-dig or a reduced solution is not feasible. I think Mr. Pratt earlier accepted that if standard construction was used, then the tree should be assumed to not be retained. But in reality, it's not as binary as it's either no dig or reduced dig, or it's just standard construction. So in reality, we would still obviously identify a construction method that wasn't just, you know, bog standard punching straight through, and avoided as far as possible the impact on the roots.
Is there anything anyone else wants to say on this point? Okay. And was there anything that anyone wanted to say about noise and disturbance that hasn't already been said?
Thank you. It was just, obviously, you weren't able to see the plan at the end of the report, but it's referred to quite frequently within my evidence. So I just wondered if you had seen section 6 of the evidence, which talks in detail about the reduced deconstruction, and it specifically mentions about work to the surface of Backs Close.
Sorry, Madam, can I actually just ask, because this is quite important, can we have a very clear understanding from the council which aspects of our hearing statement and its appendices actually Mr. Bush and the other colleagues who've been attending today hadn't looked at or accessed before the hearing?
It would solely be this one.
So
this one wasn't uploaded to our internal public access system, so I hadn't picked up on it only being on the inspectorate system.
Just, I am a little bit confused about what's happening here. So,
so generally, all the information that comes into the council, we've got an internal storage system where we store stuff like all the application records, plans, etc. So generally, that's the first point of contact for us to go to sort of draw documents to then review to form our conclusions on planning applications. This document, there's a new system, isn't there, Kate, which you referred to?
So the new appeal system, so that all the documents are uploaded automatically, and then we have to log onto the system to see the documents. So I've had correspondence with the appellant and your case officer about some documents not being on our portal. This was a while ago, like maybe the 20th of May. So we made sure they were then put onto our portal. They sent us a list of all the ones that went onto the planning appeal, your website, and then we've made sure that they're now all on our system. So they are on our system. They just were put on the 20th of May. because
Later than that, it was the 5th.
I mean, I don't particularly want to get into the detail of what happened when, but so you have had these documents, you've had the opportunity to review them. We discussed them at length this morning on that agenda item. I understood that the plan had been missed, but now you seem to be saying
This.
right. So, I mean, where does this leave us in terms of the discussion today? Because obviously we've concluded discussions on trees.
Yeah, I don't think.
Okay, so in answer to your question, am I to take that there's no change to the council's position from the discussion this morning?
So my understanding then is that it is only Appendix F that was missed. So it's not the other appendices and it's not the actual hearing statement itself. Fine. And I'm not criticising Mr Bush at all. I understand that there's a lot of documentation involved and things do get missed. But I do want you to take into account, Madam, that the council's responses to you this morning were given before Mr Bush had sight of that document. So without the additional analysis that Mr Pratt provided in that document, I think, which we sent in, at the end of March. And I appreciate that Mr Bush is saying he's had a look at it now and it doesn't change his view, but my submission to you is that, you know, it hasn't, and I'm not suggesting we adjourn for this or that you disregard his evidence entirely, but he hasn't had the opportunity to actually sit down, you know, and consider that document with the care that I would expect him to do if he had seen it on time. So I'm not, you know, suggesting we adjourn or anything, but procedurally it's not optimal from our perspective, that for reasons that I don't blame anyone for, the council hasn't actually seen the information we provided 3 months ago and, you know, considered it with a bit more attention.
So what's your kind of suggestion about how we proceed from here?
I, as I said, I'm not asking for an adjournment, but when Mr Bush tells you that his view hasn't changed, I think the weight that you should be giving to the council's position should be reduced, because they haven't looked at the information with, you know, the care and attention that I would have expected them to do if they'd picked up on this in March.
And what's your suggestion about how we proceed?
I know what what is being said. I mean, the only sort of major changes, I mean, obviously we've had we've been able to assess the route radar analysis, we've assessed the previous information, so the only additional points are with relation to their proposals now to step up Backs Close. I'm confident that I've read enough in this brief time to sort of formulate a conclusion on the matter with my experience, so I'm still satisfied that our position would remain the same.
Okay, so if there's no objections, we can proceed as we are. Yep. Okay.
Also, that's the council's approach to the documents. Could I also just clarify through you, but from the council, I think my understanding was that all of the documents, so the hearing statement and all of the appendices, have been available to members of the public at least since May, I think. But hopefully that's the position. I'm not sure. I just want to be clear on that.
yeah, so it's all been on the portal and on the planning inspectorate's online portal the online portal since you submitted it, so back in March, and on our portal since at least the 20th of May.
Okay. Okay, so the next item on agenda is mineral safeguarding. We haven't got anyone here from the County Council, I don't believe, the Mineral Planning Authority. I just wanted to, just in terms of the policy M9, I see from the officer's report, and I don't think the position changed, that the council finds no conflict with policy M9. I just wondered if you could just talk me through that policy and how you've come to that conclusion. I'm just going to find the policy myself, so bear with me a moment.
mean, to be honest, I would just be repeating what's in the committee report. At paragraph 6.154, which is where the previous officer considered that policy. Do you want me to read it out, or is it?
No, if you've got
No.
nothing to add,
No.
that's fine. Yes.
Just trying to clarify this thing about the dates and when things are available to whom. I've looked on the public access portal, and this document with this appendix was uploaded on the 20th of May this year. I think the public had to, I think the closing date for submissions from the public was the 13th of May, if I recall. So it wasn't available to the public in a timely manner.
I would say that it was on the PINS, the official appeal. I can't think of the word. The appeal, on your website, so you can go onto that case and look up any of the documents. So it was on there. It just didn't get transferred to our planning portal. So it was available for the public, and the letter that we would have sent out had a link to those the PINS site. So it would have been publicly available.
So I think the issue here being raised is that potentially interested parties have not had the opportunity to view that document. So I'm interested in how we should respond to this, or how I should respond to this.
I would say the letter that was sent to interested parties would have had a link to the PINS website where you would log on and you'd be able to view those documents. The only thing that didn't happen was that they weren't transferred onto our portal, which was an email with Savills, where they noted that they weren't on there, so then they were put on there immediately.
I agree with that. I also note that they've been on the council's planning portal now for slightly over 3 weeks, which is, in my submission, adequate time for people to have had the opportunity to, see what's happening. People were aware the hearing was today. I do think it's fair to suggest that third parties who are interested and want to make submissions opposing the scheme, do apprise themselves of what the sort of latest position is on the portal. So I've never, I don't think, had an instance where even where a document had been missed completely, it was felt that more than 3 weeks was necessary as a period to bring, to give people an opportunity to comment. So I don't think anybody has suffered any material prejudice here. The documents have been available on the Inspectorate's portal for a very long time and on the council's portal for over 3 weeks. And my ultimate submission, which we'll come to later, is that in any event, the outcome of this appeal doesn't actually turn on what happens in respect of this tree. So I say it won't make a difference to the outcome of the appeal anyway, but I'll come on to that later.
What I'd like to do is just have a look at the letter of notification that the council sent. So just bear with me, please. I think what I'd like to do actually is just take a short adjournment, if that's okay, because I just want to reflect on this for a few moments and seek some advice. So I'm going to adjourn the hearing. I'm going to say 15 minutes just to give me enough time. Hopefully I'll be back before then. Okay, so that'll be till 3:45. Thank you. Right, is everyone here? Yeah. Okay. So I think, as in the interests of procedural fairness in this case, I think given that I understand the issues that had occurred, and even though the information was available on the Planning Inspectorate website, I think it's only fair to third parties to give an additional opportunity for written comments to be made. So I think after today, if notification could be written by the council explaining which documents were not available on the council's website until the 20th of May, if you could write to everyone that you would ordinarily write to about the hearing, and provide 2 weeks from the date of that letter for written comments to be made via the case officer at the Planning Inspectorate. And then obviously there will be an opportunity to respond to any comments that are received. So I think it's, I understand this was, a technical error, but the key thing is that everyone's seen the information that they need and has the opportunity to comment.
Could I just ask for clarification? My respectful but very firm submission is that everybody does need to understand that this is only inviting comments. Well, I'm not sure actually, because is this only relating to the tree issue, or are you suggesting that it needs to be an opportunity to comment generally on the entirety of the appeal? Because I don't think that is something that necessarily we can just agree to deal with through written representations.
I mean, clearly, the key thing here is that interested parties have the opportunity to view the evidence and to comment on it. That's only fair that people are given the opportunity to do that. As I understand it, there were some documents that were not available on the council's website, which I think your letter refers people to, until after the deadline for written comments. So this is an opportunity for people to have the opportunity to make comments in writing. I think it would be helpful if it's confined to the documents that were not uploaded, but clearly I can't control what people will write in their submissions. I think if we can look at when we come to the end of the session, I understand that the Section 106 agreement is because that's not completed and you're seeking an extension of time, the hearing's unlikely to be closed today anyway. So I think there will be an opportunity for me to consider those written representations after today.
I'm not suggesting at all that I see the issue. I'm not seeking to interfere with your assessment that people should be given a further opportunity. I haven't got any difficulty with that at all. But it just occurs to me that if actually people are going to be commenting on things that are not just, one particular aspect of the case, PINS has decided this event ought to be determined with the benefit of a hearing. And if we were in a situation where actually written representations had in effect been made on, the entirety of the case, I don't think, I just want to raise a potential procedural issue, which is that it may be that hardly anybody says anything or nothing that we haven't already discussed, but I can see that there is at least the potential for us to end up in a position where, something is raised that actually ought to be ventilated with the benefit of a discussion at a hearing. And if this had all been dealt with without the procedural error, we would now be sat here with the ability to discuss it with you and with each other. So I have no difficulty with the suggestion that, initially you propose that we deal with this through written representations, but I do just want to flag the possibility. I think it's hopefully a remote one, but it may be that we do, for whatever reason, find ourselves asking you to just reconsider the procedure. I don't think it's, very likely, but
I understand the concern that you've raised. I mean, clearly, you're talking about potential future scenarios which are difficult to comment on now. The hearing won't be closed while that process is ongoing. So once I've reviewed anything that might be submitted, and you'll also have the opportunity to comment on that, clearly that would be the appropriate point to think about any implications of it. But that's what I've decided for today, so that's how we will proceed for now. Are you satisfied that I will put it in writing when I get back to the office? It might be Monday by the time I get round to doing that, but you're comfortable with what I'm asking you to do? Yeah. Okay. Thank you. Right, let me remind myself where we'd got to. Mineral safeguarding.
Just been reviewing the portal, and it's quite a significant amount of documentation. It's not just one or two appendices, it's the whole of the statement of case with appendices A to J, I think, and the hearing, or A to F, and then the hearing statement with multiple A to J appendices. So it seems like all of the documentation was not available before the comments had to be made by interested parties and members of the public.
I thought this issue had been resolved. I didn't realise it was sort of such an extensive number of documents that weren't made available.
If we would have been emailed the documents, we would have added them to the website. They're obviously all on the PINS portal to be viewed. So they are in the public domain.
Okay, I think that what I've suggested is a proportionate response. The documents are in the public domain. I don't think there's, aside from the point you've made about the backs close, the changes to backs close, in your view, being new. I don't, the evidence is responding to stuff that's already been in the public domain. So I think that the approach is a proportionate one. And that's the decision that I've made.
I agree, and I think that is a fair and proportionate decision. But I just wanted to have on record that we've counted 10 documents that have been uploaded since then, since the 20th, between 20th and 20th.
On the 20th.
On the 20th of May. So that is quite a significant a shift in terms of what people have had to respond to.
And the letter that we got from Horsham District Council pointed us to their website, to their planning portal. So saying they're in the public domain on a different website that the public haven't been told about seems somewhat disingenuous to think we'd know to look there. We can only look where we've been told to look. That letter was dated the 14th of April. And, given a month then to review and respond, but the documents weren't available where they were said to look, where we were told to look.
Yeah, and that's why I'm suggesting the action that I'm taking today. So I'm satisfied that that's an appropriate, proportionate response that it will ensure that everyone has a fair chance to provide comments.
Madam, sorry, I know we need to move on. The statement of case, so our initial appeal statement of case was uploaded. I'm on the council's website now. That was uploaded back in February. It was also re-uploaded for reasons I don't understand in May, but my understanding is that it's the hearing statement and the appendices to that were late, basically. And this is the last thing I'm going to say about this. I don't agree that there's anything disingenuous about the council's notification letter, because what the resident didn't say is that it begins by saying that if you want to comment, you have to go to the PINS website, and PINS will be uploading the documents to their portal, and then additionally they'll be available on the council's portal. And I agree with you, there is an issue around, what if somebody only went to the council's website and missed it? But I think the council did a fair job of explaining to people what the options were. So anyway, I agree with and respect your decision, and we'll move on with that.
Okay, thank you. And in terms of the documents that were missing, clearly, if you need to discuss that to make sure that everyone is aware of what was new, then please do that and get it right. Yeah, thank you. Did anyone from the
Sorry,
yeah.
I'm just reading Mrs. Fisher's evidence, and she does reference my submission that includes the drawing.
I'm ready to move on from this now. This isn't necessarily about one particular person accessing those documents. It's about interested people more widely. So I'm ready to move on now. Did anyone from the appellant side want to say anything about policy M9 of the Minerals Local Plan? Okay.
Madam, we're in terms of policy compliance, we would, I think we've already addressed this. We're relying on Part 3 in terms of there being an overriding need, and it not being practicable really to expect that any sort of material, well, that there's any real prospect in reality of this site actually being required or exploited for sand, I think it is.
Okay, thank you. The next item on the agenda is flooding and drainage. Again, maybe one for conditions, because I'm satisfied I've got what I need from the written evidence for this in the main. It was more just noting that the lead local flood authority had requested a condition about the long-term management and maintenance of drainage features. So it was just a question about how that would, or whether it needed to be secured, and if so, how it would be secured. But we can pick that up again in the condition session. Yes, Ms Fisher.
Apologies, but because of the kerfuffle about the documents, I think we've skipped noise and disturbance.
I think I said that I didn't have any. I'd asked my questions earlier on today on noise and disturbance, but I did invite comments from anyone. But if you've got any you'd like to make, then I'm happy to take
I just
those.
wanted to say that there are obviously two different elements, two sides to noise. It's noise that people are impacted by, but also the noise that people make. So really, I just wanted to kind of highlight as well the fact that there's going to be, particularly for plots 22 and 23, there's quite a concern where they're talking about sealed windows in terms of the noise from the Amberley Road, because that's the point where the Amberley Road is at 60 miles an hour both ways. And also acoustic fencing, which I've got some concerns about. So windows that just don't open and gardens that can't be used. I think that is really important. It's a basic human right, really, to be able to enjoy quiet enjoyment of your family home, and certainly plots 22 and 23 wouldn't. And in terms of thinking about alternative access, that would mean a 30-mile-an-hour limit being imposed further up the road, and that would mitigate that problem. So I do think it's important to kind of highlight that.
Would anyone like to say anything in response to that from the appellant side?
Yes, please. Sorry, I had a document open that I've closed. Let me just find that again, please. I mean, there isn't an issue in terms of non-opening windows. That's a standard acceptable design response. And to the extent that that may, in due course, be reflected in, the price that people are willing to pay for those properties, I'm sure there are many people who would be absolutely delighted to be able to, given the housing need in this district, I'm sure there are many people who would be delighted to live in a home, notwithstanding the fact that, there was alternative ventilation requirements. The external amenity point, so it's not the case that people won't be able to use the gardens. There are two relevant thresholds in the British standard, and one of them is for a desirable noise level, but then there's an upper limit of 55 decibels, which everybody will be under. So it's not basically, although the desirable criteria isn't achieved in those two gardens, they're still, within the bounds of the British standard, and the council is in agreement that the position, even for those two gardens, with the mitigation in place, won't mean that those gardens experience, significant adverse impacts through noise. So the response has achieved compliance both with the NPPF and with the council's own policy, and that is common ground between the appellant and the council.
Would you like to add anything?
No.
Did anyone want to say anything else on flooding and drainage? Okay, that brings us on to the benefits of the scheme and the planning balance. I have, of course, seen the list of benefits that the council set out in the officer report and also that the appellant set out in the statement. I think both those documents set out the benefits identified and the weighting that you each ascribe to them. And clearly I will make my own judgment on those matters. Just a couple of questions from me is how far the delivery of open space on this site would be a benefit, having regard to the comments from third parties about the change to the existing informal arrangements. And if I can come to, I'm not sure who's going to pick this one up from the appellant side, but if I can come to you first.
I think that might fall on me, Madam, or anyone else as well who might want to add in. I think in relation to the scheme, the proposed offer do provide public access to areas of green infrastructure and open space, mainly the linear area along the northwest and western boundary, which incorporates alongside the stream and where the attenuation basins are, following around the western part of the site. So that does provide opportunities for continued enjoyment of that green infrastructure in that area. Similarly, I think a point we made earlier relating to the northern part of the site when we were talking about the character effects, is that the arrangement of the main road through from connecting into Backs Close allows that openness and permeability for people accessing the site and walking into it, and allows that sense of the space and the trees surrounding, and also views over and above the site towards the south, downs to the south. So that's the experiential benefit, if you like, of that space that's being provided, and that access that will be permitted within the site, allowing residents to enjoy this space with their surroundings beyond their gardens.
I think in terms of the planning balance, Madam, I mean, we're not claiming this as a benefit. I think our position is probably that it's neutral. I think in reality, if we were dealing with a field that wasn't, that, as I said, the use is on an informal basis here in terms of its legal status. But if we had a field where there was no evidence of any sort of current recreational use, then we would, I think, be pointing to what we're providing in the scheme and saying that that is a positive benefit. So our position is that it's neutral in the sense that there is evidence of informal use by members of the public at the moment, but insofar as they would, I'm sure, say, well, turning it over to housing is then a negative effect because we lose that. Our response is, well, not really. Overall, when you take into account the points Mr. Hughes just made, those are benefits, and overall we say it comes out at a sort of neutral position.
That's clear, thank you. And to the council? Do you want me to repeat the question? It was just how far the sort of open space provisions that are proposed, how much they should be counted as a benefit of the scheme, particularly given the concerns of third parties around the sort of current informal arrangements and how those could potentially change.
Yeah, I mean, I wouldn't want to add anything more than that's already been included in my statement or the statement of common ground. So I think I'd probably remain neutral on that.
Okay. And then the other benefit, which I think is mentioned in the appellant's statement, the SIL contributions, I think, are listed as a benefit, and I just wondered whether those should be, or how far those should be considered as a benefit of the scheme.
I don't think I need to add anything to, just make sure I'm in. Yeah, in the hearing statement, in the table of benefits, Madam, you're correct. We have listed it, but we're only claiming limited weight, and I don't think there's anything that I need to add in that respect, if that's clear enough for you.
Thank you. I understand your position. Anything that the council would like to say? No.
I'd just like to say I don't feel it's neutral benefit. It's quite a significant amenity that is used by the public and residents. And as a resident, I back onto that field, and I know how many people use that field. When you do your site visit, you'll be able to see there are well-worn paths around the perimeter. It's used very regularly by many people in the immediate area and surrounding areas, particularly for dog walking. So to say the loss of that would be neutral, I think is, I fail to see how that's you know, is true.
So, in terms of the carrying out of the planning balance, as you know, that's a matter for me. I wasn't particularly going to ask any questions on that. I know from things you've said previously today that you'd like to say something about the planning balance. I wasn't going to invite closing statements as such, but is there something you'd like to say around the planning balance?
Yeah, I haven't prepared a closing statement, and I'm not going to go through, you know, sort of methodically the entirety of the appellant's case at all, but I just want to touch on kind of where we say that we get to with the benefit of the discussion that we've had today. And in particular, there's obviously been a lot of discussion around Tree T2. As you know, our primary case is that there's sufficient evidence to satisfy you that a no dig or a reduced dig solution is feasible, and to conclude that there isn't a risk or any harm in relation to the potential of the tree being removed. And if that's your conclusion, then the council's statement of case identifies the loss of that tree as the main landscape concern identified in the refusal reason. And so my submission is that if you're satisfied that the tree will be retained, then the main landscape concern falls away. And I didn't see a suggestion from the council in its statement of case. They've put their element A and element B, I think it is, and element A is the sort of wider landscape effects, including the national park effects. I didn't see a suggestion from them in their statement of case that if that's the only harm, then they still say that planning permission should be refused. And for clarity, our position on that is that if Tree 2 is staying, then on any view, the limited amount of wider landscape harm wouldn't come anywhere near to sort of getting over the tilted balance. So that's our position. If you're satisfied that sufficient evidence has been put forward to show that a no dig or a reduced dig solution is feasible. But the point I wanted to come back to, and why I say that actually in reality the outcome of this appeal doesn't turn on whether we can or can't retain Tree 2, is because the council has a 1.7 year housing land supply. This scheme is providing 30 units of housing, and 11 of those are affordable. And the council's planning officer who analysed this recommended that planning permission should be granted. So the council in its statement of case says in terms that it thinks the loss of the tree not only outweighs all of that, but outweighs it significantly and demonstrably. And I'm afraid my closing submission to you is that that position is just not sustainable. I've never heard a local planning authority suggest that the loss of one tree, which is a category B tree that's not even a veteran tree, I've never heard a local planning authority seriously suggest that the loss of a tree outweighs, and indeed significantly demonstrably outweighs, the provision of 30 units of housing, and certainly not where they have a really not very good position, putting it very politely, on the housing land supply. And the final thing I want to say on the planning balance is that Councillor Fisher referred to the human impact, and she's referred a lot to the impact that she says the scheme would have on existing residents, particularly in Backs Close. Now, I completely agree. Of course, you need to, and I know that you will, take into account everything that they have said, and you need to consider their interests. But the people that Councillor Fisher hasn't mentioned at all today are the many, many people within her council's district who are, for example, waiting for affordable housing. And the suggestion that the urgent need to house people should be thwarted because of the loss of a single tree, I am going to close on the basis that that is just not credible as a suggestion.
That's understood. Thank you. Can I come to the council first, if you'd like to say something about the planning balance?
Yeah, I'll read out a short statement that isn't a closing statement in the same way that that wasn't a closing statement. So it is acknowledged that officers advised the committee that the harm to the character of the immediate locality that would result as a loss of the tree should be weighed moderately against a grant of planning permission. That as a result, the harm identified does not significantly and demonstrably outweigh the benefits of the scheme. This is a clear matter of planning judgment, and the planning committee legitimately took a different view on this when weighing the harm and setting this against the benefits of the proposal, applying the tilted balance. In this case, by refusing the application for reason 1, the council has determined that the landscape harm derived from the loss of tree 2, as outlined within the arboricultural officer's objection and the landscape consultant's comments, would significantly and demonstrably outweigh the respective benefits of the scheme when applying the tilted balance. In reaching this decision, the council has not overlooked the undoubted benefits of providing 30 new residential dwellings, including 11 affordable homes, which would contribute positively towards the housing land supply in the district. However, the council considers that the harm arising to the character and landscape as a result of the inevitable loss of tree 2 would be a significant diminishment so as to weigh against these benefits.
Thank you. That's also understood. Ms. Fisher.
Thank you. So I would like to refute the suggestion that I have not acknowledged the benefit of housing for the residents in the district and the ward that I represent. I completely acknowledge that, and I have said several times that I recognise that the housing is important, which is why I have suggested that not only the loss of the tree, but the impact on amenity and basically the daily lives of all of the residents, not just of Backs Close, but of Downside and Warrencroft, and also Newtown Road, Foxdale, all of the houses that are basically will be impacted by this, many, many people. That is really significant. And the appellants, I think, are not really being fair in the fact that they have promised to residents that they would be able to get construction traffic coming in through Amberley Road, and they haven't adequately, because we've heard from them that they've only considered one option. They have not adequately looked at the impact of or the possibility of finding an entrance via the Amberley Road, which would have so many benefits, protect all of those residents from absolutely undeniable, constant disruption, annoyance, safety issues, protect the tree, slow the traffic down further up the road on the Amberley Road, so that actually the residents who would be forced into the houses with the closed windows and the gardens they couldn't go into because they are getting affordable housing, actually have much more benefit, because also the safety of people using the road on the Amberley Road and Newtown Road, all of those things would be shifted. So I'm absolutely not saying that there shouldn't be housing. We know we need that. And I really actually don't think that's a very fair representation of what I've said. But I also very strongly think that we need to think about all of the impacts of this on everybody, the people who need housing, the people who live in Backs Close and around there, the people of Storrington, the impact on traffic, the impact on landscape, amenity, and the South Downs National Park. They all need to be considered. And on balance, my view is that if we're going to go for houses there, we should make sure that they work for everybody. And I'm putting forward a suggestion as to how to do that. Thank you.
Thank you.
Madam, this is just a factual point. It's not this. There was a clear suggestion from the councillor that the 2 properties that experience the amenity noise issue are affordable units. They are not. They're market units.
Anything else on benefits or planning balance? Yes, sir.
I just want to add a final point, just to add to what Claudia had said, that the appellants were sort of saying that the council at the original hearing recommended that the proposal go ahead, and were balancing that with saying, and this is all about a single tree. Well, at the original planning meeting, that was put to the council, and the council, the elected representatives, decided to refuse it. And I think that should be borne in mind, and not sort of suggest that the council were giving approval and that it's just all down to a single tree. There are all the other factors that Councillor Fisher has just identified.
No, I'm responding to that. That's completely inaccurate. The elected members who went against the recommendation of their professional officer articulated the reasons for refusal in the decision notice, which do not identify as sufficient cause for concern, I think, any of the points that Councillor Fisher has raised in relation to the impact on amenity of residents in Backs Close. That's not part of the council's case, nor is the council suggesting that an alternative access of Amberley Road is something that we have failed to explore that we should be delivering instead. So I'm not criticising the gentleman because he isn't the council, but the elected member's decision is reflected in the decision notice, and then the council representatives who are in front of you today, so Ms Turner and Mr Bush, are putting forward the council's case. So the council's case is as per the council's statement of case, and as I've explained, the primary concern is the tree.
Okay, well, last comment, yes.
So I would just like to say that I was at that hearing at the planning committee. I wasn't able to challenge, I wasn't able to debate. I'm not a member of the planning committee. It's a small planning committee. I was on the planning committee before the constitution was changed, and I can assure you I would have raised these points and made it clear. I did in the submission I put, but it was a timed 5-minute submission, and that was it. I firmly believe that those issues were not explored fully at that planning committee meeting, and it's not just about a tree. I also need to make it very clear, I am speaking as a ward representative, not as Horsham District Council, so we have separate views and approaches to this.
And just to confirm, as I think I've said already today, I will take into account all of the comments received from all parties. So there is any other considerations and matters on the agenda there? I don't have any. Does anyone else have any that they'd like to raise that haven't already been raised? Okay, so that brings us on to the planning obligation. Just bear with me while I find my document. So in terms of the written update that was provided this morning, I have read that and understand it. Is this a different document?
I mean, it's the same without draft written on it.
Okay, that's fine,
Which
yes.
I can just
If you could just email a copy to the case officer, that would be ideal. But there's no changes to it from the version that I've read.
I mean,
Is that right?
I don't think so. I hope not. should be the same.
It's the same version, but without the watermark.
I think it's the same version. I think we might have taken out the signature panels. There was some issue around whomever it is that would have needed to sign it not being able to, but so I have explained to Ms Turner that if she's able to confirm to you verbally now that it's an agreed document, then as far as I'm concerned, that's the position and that's fine.
It's really just an update on where we are, just to reassure you that we're nearly there and it's coming.
So as I understood it from the document, that there was agreement now on what needed to happen. It was just actually doing the drafting and making it happen. Is that an accurate position? Okay, that's fine. I understand that. If you could email a copy of that to the case officer, that would be great. Thank you. So then taking the document on that basis, I've got some very detailed points, and then I was just going to sort of ask you just to talk me through the main clauses in brief, but just some sort of typographical things. I think the definition of planning permission, so I'm having to work off the document, obviously I received quite late yesterday, so bear with me. I think it just refers to planning permission granted by the council, whereas obviously if the appeal is allowed, it wouldn't be that, so just to point that out. And in terms of the plans that would be attached, which plans would those be?
So I can probably answer on that. We have 3 plans listed at Schedule 1. So we've got the application site plan entitled Site Location Plan. Number 2 is BNG Location Plan entitled Land at Backs Close, Storrington, Proposed Location. And the 3rd is BNG Land Plan entitled Backs Close, Storrington, Reptile Mitigation Area and Proposed Off-Site BNG. So one of those 2 provides the location of the mitigation and the other one provides the detail.
Okay, and that was just kind of one of my general queries really, was about what sort of statutory biodiversity net gain and what is mitigation for the scheme, and are they being kind of pulled together as the same thing?
No, there's no double counting of the land. They are separate areas and they're measured areas, as I think set out in the ecological report and the reptile mitigation report. But let me get you that reference.
Yes.
Sorry if this comes over as stupid, but where's access to this document that you're discussing? Is it something that is internal?
It is on our website, on our portal now.
What's it called?
Draft legal agreement.
Oh, draft legal agreement. Okay.
Just go with the most recent date. So I think it might have been yesterday, the day before.
Okay. Thank you.
Do you want a moment to pull that up? Have you got it?
Not yet, but I will look. Thank you.
And so the reptile, so there is a plan listed in Appendix A of the Statement of Common Ground, which are they the same plans, I guess? So there's a reptile mitigation area and proposed off-site BNG plan. Is that the same? Is it the same off-site site as shown in that plan?
Yes. Yes, there's an area outlined in red and an area outlined in blue, and one of which is BNG and one of which is relocation.
Okay, so the site's kind of divided into 2 discrete areas. Yeah.
Yes, the northern edge is the BNG, and then the larger area is for the relocation. Sorry, switch those around. The northern edge is the reptile mitigation area, and the larger area is BNG.
Okay, thank you. And I mean, it says it in the document, but just so I'm clear, are both of the main parties in agreement that the obligations meet the relevant tests for planning obligations? And does the council have any concerns about the effectiveness or enforceability of the planning obligations? So I was just wondering if just very briefly, can you just sort of talk me through, because what each of the clauses seeks to do, not in any particular detail, but just sort of a general, just because it sort of came to me quite late yesterday. So if you could just kind of briefly talk through each of the clauses, sorry, the schedules, and just kind of explain to me roughly what they do.
Okay, no problem. I'll give that a go. So, Schedule 2 addresses affordable housing, gives appropriate trigger points for the provision of an affordable housing scheme, and for the delivery of the affordable homes before a certain number of open market sale homes are occupied. And so, do you need any more detail on that? Or?
No, that's fine. I understand the detail. It was, but yeah, if you could just keep going with the other one.
Yeah, no problem. The third is a specimen deed of nomination rights. So a draft nominations rights deed to be entered into by the affordable housing provider.
And that was where I just had a question. So it's sort of blank in the document that I've got at the moment. Is that an agreement that will come at a later stage, or how does that work in terms of it being as part of this agreement?
Yeah, we typically submit them in draft, then sign them before the nominations are made. I guess that whilst we ourselves are an affordable housing provider, in many cases that the affordable housing provider might not be on board at that time, so they typically come in draft at this point, and then get confirmed later down the process.
Okay, so the purpose of it being in this document now is because that's the form that the final version would need to take.
Exactly.
Yeah.
Okay, Schedule 4 relates to managed land, so it's provisions for the setting up of management company, ensuring that the open space and the BNG land is kept up to the required upkeep. And so there will be a submission of a scheme to be approved by the local authority as part of that.
And just on that open space, I'm just looking at the definitions here, but does that include the management of the sort of drainage features that are proposed, or is that a separate matter?
I would expect that to be separate. I don't think it's it doesn't refer to them in terms of managing them from the perspective of maintaining their drainage capacity. So yes, it's more, if there were more like play facilities and parks, that would sit within this. It's more like,
That's fine. Yep. Yeah. Thank you.
And moving on, Schedule 5 is securing the biodiversity net gain improvements for the required 30 years, and provides the BNG monitoring contributions to the local authority. And that's the end of the schedules.
I think there's the air quality one as well, but just can you just sort of explain to me, does the Section 106 seek to secure the reptile mitigation strategy, or is that not included within the Section 106?
It's not in the Section 106. It is within the conditions. So it's down as condition 16.
Yeah, we'll have a look at that when we do the condition session. And then I think there is a schedule 6, I believe, which is the air quality.
Apologies, my print off has failed me, but I will.
So yes,
quickly
it's
revert.
a single page, Madam, but this is requiring the owners to submit a voucher delivery scheme and essentially to make available to the occupants public transport vouchers and or cycle equipment vouchers. Essentially the underlying aim being to facilitate non-vehicular, well, not non-private car, I imagine, transport.
And is that necessary, that obligation?
We accept that it is. I think it's the council who've initially kind of provided the narrative as to why, so I'll look to them, I think.
I believe this was dealt with at the committee previously, so that's where this has come from. So we recommended that this was secured via an obligation. I can look at the committee report, but it's something that's been it was discussed from them. Yeah. So the submitted air quality assessment, which air quality management. Yeah, so there's a Storrington air quality management area, which means that the air quality assessment was required. So I'm assuming, so it's in accordance with air quality guidance for Sussex, a submitted air quality assessment includes a modelled air quality damage cost calculation of, and then a fee. So that's how we're securing what was recommended within that air quality assessment, which I assume was submitted by the applicants.
Okay, thank you. So to be clear, it is your view that it's necessary?
Yes.
Yes, Madam, it's 6.158 to 6.161 in the officer report that provides the explanations as to why that is.
Just a couple of things. So, point of information, Storrington is the only air quality monitoring area in Horsham District Council. It's suffered serially for many, many years from very, very poor air quality because it has 500,000 vehicles passing through it every single month, which is why traffic is such a concern. In fact, it's only one of 4 air quality management areas across the whole of West Sussex, the others being in Worthing, Crawley and Midhurst. It's the only village that actually suffers from such poor air quality. So that's one thing that just is important to put into the mix, why the concerns about traffic are such an important point. But the other thing, again, you'll have to excuse me, I've never been to an appeal hearing before, I don't really know how they work, but is this actually being agreed, this S106 agreement now? Or is it just finding common ground? Don't really understand what the process is that's going on here.
Can I just ask someone, whether it's the council or the appellant, I don't mind, just to explain the process here?
Yes, so it's an agreed document. It isn't signed, and it's a deed in the same way as you have deeds to your house. So it requires official execution and engrossment to be binding on the parties to it, but it's not a document that the inspector basically the terms are agreed between the council and the appellant, and then it's for the inspector to decide whether that addresses whatever concerns she may have. So it's not a document it's not like the conditions where the inspector could vary the drafting. Basically, the document as agreed goes to the inspector, who doesn't have power to vary it, and either the inspector is content that, taking into account the document, the planning matters have been satisfactorily addressed, or she might conclude that the section 106 doesn't allay whatever concern she might have in relation to the scheme. But yeah, the key distinction between the section 106 and the conditions is that the inspector doesn't have power to vary the document because it's actually a sort of contract between the council and the appellant.
So my understanding was that ward councillors would have sight of the S106 document, and I've not been shown this or seen it. I didn't know it existed. So it's being discussed between the council and the appellants, but the ward councillors haven't been shown it or been asked to have view on it. And I think that's actually quite a big omission.
That's a matter for internal discussion and potentially complaint internal to the council. It doesn't alter anything in terms of the status of the section 106.
I don't have anything on to say on that. I think that might be. I mean, the draft document was submitted with the appeal, and it's a document that I will, it's in the evidence, so I will be taking account of it. But in terms of internal consultation procedure, I think that's probably something you need to discuss with the council.
Is it possible to have included that it will be agreed with the ward councillors as well?
No, that's...
I have the power to do, I'm afraid, but I think it's what...
Well, I just want to flag that's something that's quite a concern to me.
I think that's something you probably need to pick up with the council outside of this process. Okay, I mean, I don't have any particular. Obviously, I've got that document. I understand that you think that it could be completed by the 30th of June. Is that the right date? So I don't have any other questions on it. Does anyone have anything else to say about the planning obligation? Okay, that brings us on to conditions. So I know I've sort of flagged just some questions about the conditions as we're moving through, but I think if we go through the list as it is in the statement of common ground one by one, and hopefully we'll pick up those issues as we go through. So firstly, condition 1, I mentioned earlier about the list of plans and documents for approval. Was there any discussion on that during the break?
I think from our position, it's just the plans that are listed at the start of Appendix A, and then any of the documents shouldn't form part of that, because where relevant, they're referenced in specific conditions.
Okay, so the plans would be all of those on the front first sheet, and then down to the floor and elevation plans, house type 3BH12 detached, above accommodation schedule.
There's a couple more. Yeah. Sorry. Yes, that's correct. Everything down above accommodation schedule.
Okay, does do you have any comments on that?
No, so just to be clear, that wouldn't include, I'm going to go back to it, I'm sorry, that the plan that was submitted as an appendix that included the sections for the tree, going over the tree roots, it wouldn't include that, would it?
No.
Because that's not listed.
No,
just
no,
big...
and yeah, I believe there's another condition.
My proposal in respect of, because this was a question you raised earlier, Madam, I haven't had a chance to discuss this with the council because we ourselves were trying to sort of get as far forward in our thinking on the conditions as we could over lunch, but you were asking how could we make sure essentially that a no dig or a reduced dig construction method could be secured. My sort of starter for 10 on that was that we could have a condition that says prior to commencement, details in respect of the site access, including for a no or reduced dig construction methodology, be submitted and approved by the council, and then it could go on to state obviously that the development would have to then be built out in accordance with those approved details. So that's how I would suggest we could ensure that either the scheme comes forward with a reduced or a no dig construction, or it won't be able to come forward at all.
Okay, I mean, I think given that we are going to have this extra consultation period and there's some time for the completion of the Section 106 anyway, I think as we work through the conditions, what might be helpful is if you could do a revised list within that time for the same deadline, basically, as the Section 106. So if we talk through them today, and then that will give you the opportunity to consider revised wording or any additional conditions that are needed. I mean, in respect of the no dig, reduced dig solution, just when you're preparing the draft, clearly I haven't yet formed a view on whether a no dig solution is feasible here or not. So clearly you might want to just, take account of the wording of that condition and how it might, the effect it might have on any planning permission that could potentially be granted if it was found not to be feasible. But I will leave that with you to think about. Does that make sense? It's late in the day, so I'm starting to. But I think. I think the point I'm making is that if the condition along the lines of what you just suggested, if that was found not to be achievable.
I see the point, Madam. I think what you're saying is I make clear this is obviously hypothetical, and I am not suggesting this is what you're going to find, but it's possible that you could find that a no dig or reduced dig solution isn't feasible, but then decide to grant planning permission anyway, because you take the view that even if the tree goes, the benefits still, indicate permission should be granted. Maybe this isn't where you're going with the point, but if that was the basis on which planning permission was granted, then the requirement, that condition shouldn't be there at all, because it would be obviously unreasonable to say, I conclude that a no dig solution is not feasible. I'm going to grant planning permission anyway, but you must have a no dig solution, so it wouldn't pass the tests for a condition.
I understand.
I don't know if that makes sense. But
I understand the point you're making. I'll leave it with you to come up with some wording that can be.
I think it's not. I can't immediately, and I know that's probably because it's late, but I'm not sure that even if I go away and think about this more, I don't think it's actually about the specific wording of the condition. I think the question is, in what circumstances does such a condition pass the policy test? And so, yeah, I think probably, and obviously it's for you to decide what you put in your decision letter, but I think it would be helpful if in your decision letter you did express a view on the feasibility point, because, as I said, if the conclusion was it's not feasible, then it wouldn't be acceptable to have a condition requiring us to do something that you've said you don't think we can do. So I'm seeing nodding from Mr.
Fully agree with what you're saying there. I mean, with regards to your wording of the condition, it does actually quite similarly align with what we've prepared as well. So I think we probably could knock our heads together and find something.
Yeah, we'll take that away, Madam, and then we'll seek to agree a wording to address the situation in which you decide that it is feasible, and then obviously it will need to be conditioned, and we'll probably also just set out in writing our respective positions on when that condition should or shouldn't be included in any grant of planning permission, just to try and assist you on that point as well.
Okay, thank you. Right, so I think that's just some very points of detail on the list of plans. There are some differences in the drawing titles between those in the first column of the table on Appendix A and the title of the drawing. Should I be taking the titles of the drawings from the drawings or from the table?
The drawings, because and thank you for identifying that, because yeah, the drawings should govern the position, and we should also seek to avoid any inconsistencies, because obviously then if someone looks at it further down the line, there'll be a question mark. So we will look again at that table and make sure you've got in the revised conditions, and maybe even in a revised Appendix A if need be, but that there isn't any discrepancies there.
I think if because you're going to be putting together a revised schedule of conditions anyway, if we could just have the approved plans listed out. I do know that there were some amendments made to correct some typographical errors in column 2. I think they've just been referred to in different ways. In is my guess in column 1, but there are some differences between the titles on the drawings and in that column. So if that could all be picked up and put in a consolidated list of conditions, that would be helpful. Just as another point, the drawing references include the job title, whereas the drawings have a separate job title and a drawing number. So again, it's just for in terms of enforceability, just making sure that that's all as it should be. So if that could just be picked up. And then a very, which I think is another typographical error on the landscaping proposals north drawing. I think although this will need to be checked because it might be me, but the column, the second column refers to P22 2065. I'm not sure if that should be 3065, but if you can just check that. Okay, condition 2. It says time condition. There's not actually, I assume that's the standard time condition, 3 years. Condition 3, I didn't have any questions or comments on, but does anyone else wish to make anything? Yes.
We just wondered whether it should reference foul as well as surface water there. Just considering what was mentioned earlier. So it would just be adding in a detailed surface water and foul drainage scheme.
Any comments on that?
Yeah, it might be that it's covered somewhere else when we go through, but I don't think so.
Any comments?
I can't immediately find a reference to foul drainage anywhere else, so I don't think we've got any objection to that suggestion.
And I assume you're recording these to
looking around, I'm doing my best, but hopefully between the lot of us we'll catch all of these points.
Sorry, I also wonder whether this is where we include details in relation to the pumping station, or if that is somewhere else.
That's already.
Oh, that's already. Okay.
I think it's the next one actually.
Okay.
Number 4.
Yes, it is.
Okay, I don't have any comments on condition 4. Does anyone else?
Just to say, do we need to pick up the point about indicatively in that condition as well when we?
Yes.
A
I think that does
one.
need to be picked up. Yeah. Condition 5. I just wanted to kind of talk through the trigger for this condition. So at the moment it's requiring effectively, I'm summarising, but details of the solar PV equipment to be submitted before construction starts on that solar PV equipment. Clearly, if construction doesn't start on the PV equipment, would PV equipment be secured? I guess is my question.
I appreciate that that's probably not well defined. Whether that, foundations or superstructure. So could we make that prior to commencement of superstructure?
What's the intention of the condition here? Is it to make sure that solar PV is installed in accordance with details submitted? That's the intention of it, is it?
I read it actually as just enabling, because it just says the reason just says the council wants to control the design and scale of the PV equipment. So I sort of read it at the moment as saying, in the event that solar PV equipment is installed, we want to make sure it looks good, and not as you must install solar PV equipment. But it's the council's drafting, I think. So
as from our experience, that would be, I imagine, the specific model and quantity that you would need for each rooftop, as opposed to kind of just the general figures that went into the energy assessment. So I'd expect it to be about that level of detail. So by the time you're kind of building out your superstructure, then that would be an appropriate time for us.
Okay, I think it's just if you could look at the trigger and just to be clear, is this just saying basically solar PV should not be installed other than in accordance with details that we've approved, or is it actually requiring PV to be installed and making sure that happens? I don't think that's clear in the triggers that are in that condition. So again, if you can just look at that. Condition 6, I've got the point that, or there's a general point around the construction mitigation measures, and I'm just seeking views really on whether this condition would satisfactorily secure the construction mitigation measures for ecology that's within the ecological assessment.
I believe so. This condition was drafted with reference to any requests from ecology, so it should be taking into account everything that's been asked of us, of the appellant, sorry.
Okay, thank you.
I just note condition 16, and more sort of straightforwardly just says the development shall be undertaken in strict accordance with the ecological mitigation and avoidance measures set out in the ecological assessment and the reptile mitigation method statement. So one way or the other, I don't think there's a world in which we can just not do what we've said we'll do in those two documents.
Okay, any other comments on that? Is there a comment pending?
We were considering the point about construction activity beyond dusk and how that would best be incorporated. So this would be an appropriate point. We're debating whether it should be a reference to dusk or inclusion of a reference to the document, but maybe simply just reference to dusk.
Okay, maybe that's something you can consider when you're doing your revised list of conditions anyway.
Yeah, we were a bit concerned about dusk being quite vague, and before we talked about sunset, or I don't know, but maybe there's a discussion later.
Okay, we'll see if there's an internationally accepted standard.
Yeah, I mean, I think the shadow HR, as I read it, the shadow HRA was quite specific about lighting during the evening. So yeah, just I was just a bit concerned that this sort of talks about flood lighting.
Maybe there needs to be a kind of a portion on lighting, and then that will include an appropriate time for each season that can stop activity. So if there's a provision for lighting and the activities related to lighting, then that can form part of our submission.
It might be as simple as the condition requires proposed working hours to be submitted, and we could say that there needs to be reference to the document that says when working hours are actually allowed, and that would reduce the flood lighting. But we can take that away and propose some wording around that.
Yeah, and clearly, you know, in terms of if I'm undertaking an appropriate assessment, I will be taking into account the mitigation measures that have been put forward in respect of bats, particularly, and the effects on the men's sac. So I'm pretty sure those mitigation measures included no lighting during the construction period. But you can check that and think about that one.
Madam, I mean, I think that I agree with you. We can probably make the petition clearer and make sure there's no sort of ambiguity between the conditions. But I think insofar as the ecological assessment does say things about no flood lighting, then which condition was it? 14, I think, on ecology. Actually, 16, more indirectly, I think, does already sort of hold us to that. So, but I don't think it would be a bad idea to see if we can just make it a bit more specific. I think the reference to any flood lighting, it's not saying there will be flood lighting, but yeah, we can look and see if we can make that a bit smoother.
Condition 7. Sorry.
Yes, sorry. Again, I just don't know where this document is. I don't know what it's called. I've searched for conditions on the...
This is Appendix A of the Statement of Common Ground. No, it's not Appendix A. It's Appendix B of the Statement of Common Ground.
Is that on the portal?
Condition 7. I just wanted to double check the wording there. Says that the detail shall accord with the landscaping proposals in the arboricultural method statement. What does that actually mean?
I mean, yeah, we need to take that away and tighten it up, Madam, because I don't think landscape, well, it's not the worst wording that I've seen, but landscaping proposals is a bit vague. So we'll tie that down to some plans or some documents.
Condition 8, I didn't have any questions on. Does anyone else want to say anything in respect to condition 8? Condition 9, I just wanted to double check. So there's a condition in the condition wording in the first column, and then some suggested update in the second column. Is that agreed? That second wording. I'm not sure who's written which column here, so I'm not sure who to address the question to.
Is in that section.
I think that was agreed between the two parties. It might be that there might be a slight amendment following what we're talking about now, but I think it's the second column that is the one that's agreed at the moment.
Okay, so if you're doing a revised list, then that could just be moved over, and whether it's an amended condition or an additional condition in respect of the construction method, I'll leave that to you to make suggestions.
Yes, I mean, insofar actually, Madam, as this presentation of the conditions is a table with sort of the parties' respective positions, we will dispense with that, I suggest, and just agree the wording between the two parties. And if there are any points where one party or another is insisting that a different approach should be taken, we'll clarify that for you, but I'm not sure. I think it's not necessarily ultimately so helpful for you. I think it would just be clearer if we just give you the agreed conditions, and then if there are any points that are outstanding, we'll just make that completely clear to you.
That'd be helpful. It can just come with a covering note and just. Didn't have any questions on condition 10 or 11. Does anyone have anything to say about those conditions? Condition 12. Oh, it's just a minor point. This condition refers to paragraphs 4.13 and 4.14 of the ecological assessment. When I went and looked at those paragraphs, I think 4.13 relates to the construction period, and I wasn't sure, therefore, if there was some overlap with the earlier condition we were discussing. It's just something to look at and just be sure that, yeah, thank you. I don't have anything on 13. Anyone else? Condition 14, I think if you could just have a look at the wording, I think there's been some amendments that have sort of been incorporated, but maybe not fully. I think I know what it's trying to do, but if seeing as you're looking at the conditions, if you could just check the wording of that. I think, as I understand it, it's trying to seek a timetable for implementation of the soft landscaping proposals as part of the landscaping scheme. I'm not quite sure it says, you'll see what I mean when you read it. Condition 15, this is a very pedantic point of detail, but I'm always focused on enforceability. The condition refers to the 2nd of May as the date of the arboricultural impact assessment, which is the date on the second page, but the front cover says the 8th of May. Which date should that say? Because I don't want there to be any dispute as to which document that condition that's referring to.
We'll clarify the date within the fresh list with you. I did have just a comment on 15. That's, yeah. It's just around the wording of and how for how long a period of time can no trees be felled or subject to reduction. I would just suggest as we review the conditions again that we perhaps tighten up that a bit. Is it no trees can be removed during the construction period, or is it in perpetuity? It's just tightening up that point. Also, we might consider that the AMS that we're including under condition 9 might render 15 unnecessary. Something that will.
If I may, I feel that we can probably club some of these tree ones together, as you've said, and have it all encompassed within the single condition with relation to the access and the AMS and everything like that. So I think we probably can water it down a bit.
Okay, I'll leave it to you to look at the tree conditions. Condition 16, so we've sort of briefly touched on that one already. I did want to understand a bit more about the reptile mitigation method statement and whether this condition would be effective at enforcing off-site works. Does anyone have any comments on that?
I mean, in my opinion, yes, in that I don't think that whether there is non-compliance on-site or off-site changes the analysis, in that there would still be non-compliance and then there'd be a breach of condition that the council could enforce against. I
mean, I'll leave it for you to think about as the revised schedule. I just wonder whether a Grampian condition might be a more suitable way of securing off-site works, but I would leave that to you to think about. Condition 17. Does this condition secure the implementation of the wall?
From our perspective, the wall is part of one of the plans listed in the plans condition, so it's on a boundary plan, so it should secure the implementation of the wall.
But just because it's on the plan, does that mean that you'd have to deliver it?
We were going to suggest that there could be some wording added to the end of that condition that says retained as such thereafter, or something similar. So we can revisit that when we look at the condition schedule.
Would the intention be for the wall to be in place before the occupation of the dwellings?
Yes.
I don't have anything on condition 18. Does anyone else? And condition 19, it refers to an approved drawing number, but there isn't a drawing number there. Which drawing is the one that shows the car parking spaces?
mean, the soft landscaping plans do show the parking spaces, so it might be that one of those could be referenced.
Again, shall I leave that to you to look at? Just to clarify which drawing should be referenced there, because I mean it refers to the car parking spaces necessary to serve each dwelling. I sort of query whether that's precise enough for what this condition is trying to achieve, but I'll leave that with you. I don't have anything on condition 20. Does anyone else?
Sorry, Madam, just to return to condition 19, I think the only way that I could see I think that condition probably is specific enough. The only thing I can think of that would tighten it up would be that we would have to have a plan that actually sort of gave unit numbers and then put the same number, I think, in the car parking space, because I can't really see how else we could provide any additional clarity on that.
I mean, I guess just, you know, from my perspective, if I wanted to know how many car parking spaces each plot was, you were proposing to provide for each plot, how would I know what I was enforcing if I was the council, I guess is my question.
Yeah, I think, so I'm looking at the site layout, which does give, in the gardens, it does give unit numbers. So I think the only way we could sort of really put that beyond absolutely any doubt would be to have a revision of this plan that also has those unit numbers in the corresponding car parking spaces. So, you know, number 33 would then have a car parking space or two with that number indicated on those spaces.
I mean, I'll leave it to you to consider how to do that. I think it's just, I may be making an assumption that the condition is seeking to secure a specific level of parking, and I'm not sure from what I've seen that that's. I'd be clear exactly what was being enforced there, but I'll leave it for you to look at and to make suggestions. Condition 21, I think we did, I sort of touched earlier on plan SK04. I just wanted to just clarify whether the council is satisfied that that plan SK04 does provide sufficient information to know what's being secured in terms of off-site highway works.
Yeah, I believe so. Again, this was taken from the committee report, so if we're having the opportunity to go through these conditions, then perhaps I could just check that we are happy that that's the only document to be referenced in that condition.
And condition 22, I don't have any comments on. Is there anything anyone else would like to say about the conditions in the Appendix B? Yes.
So I had another question which relates to the 2-week extension, which obviously is going to take a bit of time for the letters to get to people and so on and so forth. Will that impact the deadline or the date for signing of the S106 agreement of the 30th of June? And if so, by how much? And also, is there a deadline for finalising the conditions?
We'll come on to that at the end. Just in terms of just questions really from comments I'd picked up from the consultation responses, is it necessary for there to be a condition related to unexpected contamination?
I mean, we haven't recommended one. However, it's never something that, I mean, I think it would be a good idea because it doesn't actually tie anybody to do anything unless there's an issue that comes up, which we would, but I'm not sure whether that would be considered under kind of environmental law anyway.
Shall I leave that one with you as well?
Yeah.
There's a couple of others that I'll leave with you. I'm not making any suggestions here, by the way. These are just purely questions to you. The Fire and Rescue Service requested a condition related to fire hydrants, which hasn't been included again. It might be that you've excluded that for reasons, or I'm just asking whether one's necessary. And also in terms of the details and the delivery of the internal routes, which I mentioned earlier. So as I understood it from the Highway Authority, they were sort of recommended a condition around the delivery of the internal roads and footpaths by a certain trigger, I believe, which didn't appear to be included in the list. And as I say, that might be that you've deemed it not necessary, but I'm just asking the question now. So those are all my comments on the conditions. Does anyone have anything that they would like to say? That brings us on to applications for costs. Are there any? No. And then arrangements for the site visits. Well, given it's now 5:10, I think we're certainly into tomorrow for the site visit. Did anyone have any thoughts about whether it could be an unaccompanied site visit or whether it's something that I should be accompanied on?
I think our suggestion is that it would be accompanied, but that for the 2 viewpoints in the national park, we wouldn't propose that everybody needs to go with you to see those.
Okay, thank you. Anyone else?
I mean, we're happy for it to be unaccompanied, but obviously we'll come if it's going to be accompanied.
Okay, yes.
I think there's a strong appetite from residents for it to be accompanied, and I'd certainly like to attend as well.
Okay, in that case, I'll undertake the visit on the site and sort of the Backs Close area as an accompanied site visit. I don't feel the need to be accompanied further afield in terms of my walk into Storrington and up on top of the escarpment. I'm happy that I can undertake those on an unaccompanied basis. So tomorrow, and I will unfortunately need a representative from the council there, even though I hear what you say. In terms of the timing for the visit tomorrow, is there any sort of preference over meeting time in the morning?
Sooner the better for me, if that's possible. I've got not absolute commitments, but I have got things penciled in about 10 o'clock. So if we were able to get that in first thing, would help me. But I'm not going to be held to that, obviously. It's just I can make arrangements otherwise.
What's first thing for you? Is that 9 o'clock?
Yeah, well, not 9 o'clock or, yeah, around there would be fine, I should think.
How does 9 o'clock work for everyone else?
I don't want to be holding it up. It's fine. I can be flexible. That's just my preference.
Would 9:15 or 9:30 make it easier in terms of other commitments?
I think it would, just because we both need to do school runs and then one of us will come. I don't work Fridays, but I can. So we'll just, if that's okay, one of us will be there at whatever time you say.
Do you need a definitive right now? You need to know.
We need to arrange a meeting time.
Okay.
I mean, is 9:30 doable for you?
Fine.
Yeah, let's say 9:30, if that's okay.
School runs by not being
So 9:30, and in terms of the, and I appreciate you, so you haven't quite decided yet who'll be there, but it will be, okay. So Ms Turner, and it'll be Mr Hughes from the appellant side.
And Mr Pratt as well.
Mr Pratt. And then in terms of Ms Fisher, you're planning to come. Would you? And I would make it clear that I'm not intending for there to be any discussion about the merits of the appeal on the site visit. I don't mind factually things being pointed out to me, but there should be a minimal discussion, and it really is for me to be able to see the site and surroundings. So if we can please bear that in mind. I did have a suggested site visit route provided that I think was agreed between the two main parties. That suggested parking on, or certainly that I would park on Warren Croft, where I saw there were some parking bays, and meeting at the Backs Close Newtown Road junction. Is that still a suitable meeting place? Okay, so we'll meet tomorrow morning at the junction of Backs Close and Newtown Road at 9:30. And in terms of accessing the actual site, well, maybe we can work that on the morning. If we do that, if we wander along Backs Close first, and then presumably would go along the footpath, would we, to access the site? Yeah, okay. And it looks like it might be a walking boot trip. Yeah, okay. And then in terms of, just to be clear, I've got here, obviously we've got the walking route. I'm going to walk along Amberley Road into Storrington. I'm going to visit the footpath up to viewpoint 5. I think that's the right viewpoint, isn't it? To the in the fields adjacent to the site.
Yes, we can do that as part of our.
We'll do that together.
Yeah, it's only a couple hundred metres.
I will then obviously also visit Kithurst Hill and Springhead Hill. Is there anywhere else that I should visit? Is this a different point, or is this a...
Well, it's just on the first route. I think it would be good to go up to the junction with Newtown Road and Amberley Road. That's not included on the...
As part of the site visit?
Yeah.
Yes, yeah, we can do that. Yeah.
That's just not on
Yeah.
here. Thank you.
Are there any other viewpoints that you would particularly suggest that I see? Ms Fisher? Yeah. Sorry.
I was looking at the map.
Are there
Can't
any
do two things at once?
Are there any other particular viewpoints that you would?
No,
suggest
no,
I
that's
see?
fine. No,
Yeah,
that
okay.
sounds fine. Thank you.
Lovely. So I think that completes the agenda. So we are left in terms of some actions. In terms of the consultation on the documents that were uploaded late, I think that can be a 2-week consultation from the date that you notify the interested parties of that. Yeah, that's why I'm not saying a particular date. So I think we need to give people 2 weeks to view those documents. And in terms of the deadline for the Section 106, we're saying the 30th of June. And I'm comfortable for the conditions. I mean, if they're ready sooner, please do submit them sooner. But if we just keep it neat and say 30th of June for both of those things. But clearly, it might be that the consultation process goes on slightly longer than that, if depending when the letter goes out. But if we do it next week as soon as possible. You're going to email a copy of the update to the case officer. I think that was all the other actions. I had a little list somewhere and now I've lost it in my pile of papers. And yes, that's fine, the extra conditions. Okay, is there anything I've forgotten?
Just to ask, I think you said you were going to write, or the case officer presumably was going to write out about, on this point around the consultation, but in that letter, are you presumably going to set out the response time, first of all, for the consultees, but then for the applicant to have a period of time to respond to whatever comes in?
I don't think I need to set out the timing that will happen, because I think it probably depends on the nature of what comes in, but there will be an opportunity for you to comment. Or I can just say, I mean, how long do you think you would need? It's difficult to say until you know what's there.
I think we do, well, it's a matter for you ultimately. I would suggest we do need to set deadlines, because otherwise, if somebody I don't know, there'll just be an open-ended potential for responses to come in and you won't be able to issue your decision letter potentially.
Oh no, I would set a deadline. I'm just saying I don't feel the need to set that deadline now, because I think the time would depend on what came in. Yeah.
But you are going to set a deadline for people to respond, are you?
Yes, what I've said is there'd be a 2-week deadline for members of the public to make comments from the date of the letter that the council will send. So that will be a 2-week period.
Yeah,
and at the end of that period, I will provide an opportunity for your side to respond.
Sorry, you'll confirm our response period once you've seen what's come in.
That's my
Sorry,
intention, yes.
I'm being a bit slow.
Does that sound
because
okay to
that
you?
sounds fine. Sorry,
Yeah.
I was a bit slow.
Okay. Does that sound okay to you?
That sounds good. Can I just check the additional comments that we might receive? Where do they need to go to?
I think I probably should check this with the case officer, and I will write to you, hopefully tomorrow, but it might be Monday.
That's fine.
To just confirm exactly how those comments should come in. My feeling is I'm not quite sure how our system works now that the consultation period is closed, so it might be that they need to be emailed. But can I confirm that to you when I write out? Thank you. Is there anything else that anyone wants to say then before we finish for the day? It's quite late, isn't it? So I mean, we'd like to thank you all for your contributions today. Yes, Ms. Fisher.
I just wanted to say thank you for being so thorough about it all and being so fair and open. Thank you.
And you know, all the comments are really welcome and helpful to me. So thank you for that. I'm going to adjourn the hearing now, not close it, until the 30th of June or a later date, depending on what date the consultation period is. But I will confirm that in writing. Okay. Thank you, everyone.